Stephanie Fritchell with the Public Defender's Office.
I didn't know who.
And Mary Ibram, private attorney for Mr. Spencer.
Okay, great. Okay. All right, yeah, it's in the clerk system, the Spencer case. I believe it was. Did we get that one pulled
Your
out?
Honor, sometimes it just takes a moment to upload sometimes it's just not there when it's searched. As someone who does IAs quite often, I've noticed that.
Okay, all right, let's go ahead and start then.
It wasn't there this morning.
They say we're gonna start first with the Spanish interpreter, so we'll go ahead and call on that one and get started. And if you need it, I might be able to dig in my stack and get it for you. Did she get you it, or?
Yes, I have one page, there's 4 total, so I'm just gonna read it off the computer screen, public defender.
Okay.
Let me borrow it.
Okay, yeah, it was in, I think almost all the charging affidavits, the attachments were attached. Okay, let's go ahead and begin then. The interpreter is being called.
Good morning, Your Honor. This is Laura Bretaña, certified Spanish interpreter, previously sworn.
All right, good afternoon. This is Judge Clark. We are here in case number 2023, CF 6920AO. And sir, if you would state your name, please, for the record.
Orlando Javier Claudio Aponte.
Orlando Javier Claudio Aponte.
All right, sir, you were here on a charge of fleeing and attempting to elude, no motorcycle endorsement, and street racing. Probable causes previously been found. I will appoint the public defender's office to represent you, sir, on the case. You are entitled to a bond on count 1 that was set at no bond. At this time, sir, and just because we've got, let me just go ahead and make my announcement to the attorneys. I don't ask each, I don't say, defense, what do you have to say as to this case? State what you have to say to this case. I just wait for you all if there is any additional information to let the court know. Okay?
Yes, Your Honor.
Just wanted to let you know because I realized you've been doing this for a couple days now and make sure everybody knew that. All right, at this time, sir, I'm going to set bond on count 1 in the amount of $3,500. Count 2 will be remain at $250, and count 3 will be at $500.
And Your Honor, it does seem that he qualifies for pretrial release.
Would not put him in problems, fleeing and attempting to elude, okay?
Understood.
Okay. All right. Staying to the interpreter, you can just announce this over the record. You don't need to put those back on him, or over the speaker. Sir, just stay in contact with your attorney, sir, on the case, okay?
Señor, por favor, manténgase en comunicación con su abogado en este caso.
Okay, all right. All right, I believe that.
And Your Honor, the Public Defender's Office was appointed, just to clarify.
Yes.
Thank you.
At this time, I believe that concluded our interpreter cases, so thank you very much.
Thank you, Your Honor.
You're welcome. All right. Sir, your name, please?
Sheila of DeLance.
And what is your last name?
DeLance.
DeLance, okay. Got it listed as DeLance Sheila, but I see it also says Sheila DeLance. At this time, sir, a warrant was issued finding probable cause for the offense of lewd or lascivious behavior. The court has reviewed, or that probable cause has previously been found. I will appoint the Public Defender's Office to represent you, sir, on the matter. I believe this was an add-on, so you were brought over after the warrant was served on you. At this time, I don't believe there's any witnesses or anyone that is present here at this time. At this time, sir, I'm going to set bond in the amount of $10,000 with the following conditions. You are to have no contact with the victim or any of the witnesses in the matter. Do you understand that, sir?
Yes, ma'am.
Okay. Is there anything further on behalf of the state or the defense?
No, Your Honor.
No, Your Honor.
All right, sir, you've got the Public Defender's Office appointed on the matter. Okay, and you understand the court's order about the no contact?
Yes, ma'am. Thank you.
Okay, all right, thank you.
Talk to your attorney in more detail. Take this with you. I tried to write some of your other bonds too. One case is holding you no bond.
Trying to help you by taking the items off, but I think I'm probably causing you more of a problem. All right, ma'am, your name, please?
Ariana Fox.
All right, Ms. Fox, you are here on case number 2023 CF 9601AO, and the charge is grand theft of the third degree and larceny. Probable cause, once again, has already been found. At this time, you do qualify for the public defender, so I will appoint the public defender's office to represent you. That bond will remain at $3,500 under count 1 and $1,000 under count 2. You're not to return to the scene of where this occurred. You're not to have any contact with the co-defendant or the witnesses in this matter. Okay? Thank you.
So your other bond.
Your name, please?
Jamar
Mr. Witter, sir, you're here on a charge of petty theft, having prior convictions. Once again, the warrant was already issued and signed by the court that handled that affidavit. At this time, sir, bond will remain in the amount of $1,500. You are not to return to the scene of where this occurred. And would you like me to appoint the public defender's office to represent you on the matter? Want an attorney on the case?
No, ma'am. Is there any way like I could just plea out today?
I don't, well, you've got a bond on the case. I don't know if you can post that bond today.
Due to it, like, because due to the prior sentence, like, they basically separated each petty theft.
Okay.
I just served basically 5 months on the second one. It was all at one time.
Okay,
And
you may not want to
yeah.
say anything because you don't want it to be used against you. Let me go ahead and get you an attorney to help you on the case, okay?
I'd rather not.
Well, you're going to be sitting in jail and you don't want an attorney to start working on the matter for you to possibly request a hearing?
No, ma'am.
Okay, we'll put a determination of counsel, whatever time frame y'all normally use. I don't know about what number, I don't know, Madam Clerk. A week, okay. All right, thank you, sir.
Thank you, ma'am. Have a good day.
You too. All right, I've got some documents here in front of me now, so. Henson, I believe. Okay, this is are we now on the arraignments? Okay, okay. All right, sir, would you state your name for the record, please?
Eric Lavon Henson.
All right, Mr. Henson, sir, you're here on a charge of trespass on property other than a structure or conveyance. Public Defender's Office was previously appointed to represent you on the matter, and at this time, how is your client wishing to proceed?
Your Honor, he would like to withdraw any previously to enter pleas and enter a plea of no contest. In agreement with the state, the offer is an adjudication of guilt, credit for time served, no return to the location this happened at 54 West Church Street, cost of investigation of $153.59 to Orlando PD. This was only filed as a trespass. He is still being held on the other charge. It came in false ID to law enforcement. We just want to make sure that he's released from that one as well.
I won't take any action on.
It's the same case. It was only filed.
Oh,
He
I
was
thought you meant it was an out-on-bond case. Right, they chose to file just the one count, right.
Yes, we just don't want it to be left over and
I thought-
holding him.
I thought you meant, well, he's pleading to this. now will you
Understood, Your
take care of
Honor.
The other one. All right, is this the agreement of the state?
Yes, Your Honor.
All right, sir, Mr. Henson, at this time, it's my understanding you wish to enter a plea of no contest, rather, to the charge of trespass on property other than a structure or conveyance by refusing to leave and enter a plea of no contest. Is that correct?
Yes, ma'am.
From where you're standing, sir, is this your signature on the plea form?
Yes, ma'am.
Did you read and understand the rights on the plea form?
Fully.
I'm sorry?
Yes, ma'am.
Okay, and do you have any further questions regarding those rights that you're giving up by doing so?
No, ma'am.
Are you on probation for any other charge?
No, ma'am.
And are you under the influence of any alcohol, drugs, or medication that could affect your thinking today?
No, ma'am.
Satisfied with the services of your attorney?
Completely.
Okay, they've done an excellent job, gotten you in here and, resolved the case. In addition to that, sir, do you understand that if you're not a U.S. citizen, by entering a plea today to the charge, it will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
Do you understand that?
Yes, ma'am.
Okay, and knowing all of that, how do you wish to continue with your plea? Guilty, not guilty, or no contest?
No contest.
I'll accept your plea. I find sufficient facts to do so, that you're freely and voluntarily entering the plea, and you understood the rights you're giving up. I'll adjudicate you guilty, 32 days in jail, credit for 32 days time served. You'll be released under this case today. Cost of investigation of $153.59 to Orlando Police Department. You're not to return to the scene of where this occurred at 54 West Church Street. Do you understand that, sir?
Yes, ma'am. Don't go back.
That's correct. And also, there's mandatory court cost. I will give you 1 year to pay the cost of investigation and the mandatory court cost, okay?
Your Honor, I don't know if it's possible if he can get a year and a half. He is currently homeless and unemployed. However, he is working on getting his life back together, and he does want to make sure it's not a suspension on his driver's license.
Mr. Henson, sir, I'm going to keep it at a year, and the only reason this, sir, is out of sight, out of mind. People forget, and all of a sudden it passes, and I personally think a year is substantially longer than long. But I won't start you on a payment plan. I won't make you go through collections court. But what you can do is, though, when you get out, go to the clerk's office. Don't wait, till 9 months from now to say, oh, Judge Clark said I can get on a payment plan. Go to them immediately. They'll handle a structure of payment schedule. It's something you can afford, the time frame you can afford it. And as long as you stay on that, you're not going to be in violation of not only the court order, but in fear of losing your license as to this case. Obviously, I don't know anything about any other case or your driver's license, okay?
Yes, ma'am.
All right, was there anything further from the state or the defense?
Nothing from the state.
Anything further from the defense?
No, Your Honor, nothing else from the
And
defense.
let me just make one announcement, so while the other persons are here. Also, you have the right to appeal the sentence of the court, must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed to represent you, okay? Thank you.
Everything.
If you want that sheet, please show it. Mr. Rogers, I believe.
Huggins,
Who are you? Huggins?
Michael Huggins.
Okay,
From the arraignment docket, Your Honor.
okay, that's fine. Mr. Huggins, you are here on a charge of battery.
Yes, ma'am.
Is there an offer? I doubt it. Are we-
No, Your Honor, there is no.
No, Your Honor, and it doesn't look like the Public Defender's Office has been appointed. I'm not sure if I don't believe any attorney is on the case, but I could be wrong.
Mr. Huggins, sir, do you want me to get you an attorney to start working on the case?
I would, but
I think you probably need one. We're here at an arraignment, and you've been in jail, so you want me to get you an attorney appointed?
yes, ma'am.
All right, sir. You're not working, obviously. You've been in jail. I will appoint the Public Defender's Office to represent you at this time, okay?
Yes, ma'am.
And at this time, on Mr. Huggins' case,
Your Honor, I apologize. It looks like, I haven't had a chance to check, but it looks like this case may have came in with additional charges and only the battery was filed on. If I can have a moment to confirm, and if that is the case, one, if we can delete the other bonds, and then two, Your Honor is waiting, defense will enter a plea of not guilty at this time.
as to the other bonds, aren't those heard in the division they're assigned, or is there the admin order that talks about the way those are handled, I believe?
Generally, Your Honor, the defense will file a motion
Right.
indicating that the charges have not been filed and ask for either the defendant to be released ROR or for them to be, but it is done through a motion, Your Honor.
That's what I thought. And I understand, she just got the case, but if you want to file, if you want to appropriately file that, I do see, I understand what you're saying, but I think that's one of the downfalls of not getting an attorney appointed at square one, so to speak, but understand the defendant has the right not to. But your attorney at this time, they're probably going to file some other motions. I don't know if it will or won't hurt, if I don't know it's going to help you, but at least they'll file their appropriate motions that they need to do or feel that would assist you in your case. But at this time, they'll go ahead and enter a plea of not guilty, I heard, and the matter be set for pretrial. So we're going to go ahead and give you a date in the division at this time, okay?
Yes, ma'am.
All right. Okay. I think that's who I had called. All right, and the Public Defender's Office was appointed.
And Your Honor, we'll enter a plea of not guilty at this time.
Okay, plea of not guilty, and we can go ahead and get our date for them. Okay. Then we have. My hand. Okay, your name, please?
Wilkember Fernandez.
All right, so you're here on a charge of battery, domestic violence. I'm showing the Public Defender's Office was previously appointed to represent you.
And I apologize, Your Honor, I'm just catching up. I didn't, oh, is
Yeah,
this the
It's still arraignments. Yeah, I'm doing the same. I'm,
jumping around?
because usually they're waivers filed. That's why I'm a little,
Oh, Your Honor, this one, we filed a notice of conflict where we filed a motion to withdraw due to notice of conflict on
Okay.
7/14/23. We're still pending the order. However, we couldn't file a waiver or anything further due to
Okay.
conflict.
all right. So it hasn't been, you cannot file a waiver due to the conflict?
I thought once we have a conflict, we don't touch the case anymore.
Okay, well, I hate you sitting in court, sir. I mean, well, let me rephrase that.
And there's no offer on the case as well,
Yeah,
Your
there's
Honor.
no offer, so so there's no offer, so a plea of not guilty is going to be entered on your behalf, so we can get the case processing for you, and you're shaking your head, yes, you're ready for that, I'm sure. So we'll go ahead and get it assigned, and then they'll wait on the motion to withdraw to be granted and reviewed by the division that it's assigned. Okay, Madam Clerk?
They're gonna, you're here. Good luck with everything.
Thank you. Your name, please?
Spitz.
All right, Mr. Pitts, you're here on a charge of trespass on property other than a structure or conveyance and criminal mischief. Let me look one thing up. You've got the Office of Conflict Counsel appointed, and was an information filed? Yes, no, yes. I need to, first appearance information. To the state, can you help me out? I see arraignment, oh, maybe it's just a little further down.
Your Honor, it looks as though this was, he was arrested on a felony, and then it was downgraded to a misdemeanor, but I will confirm.
It was, I see it now. I had to go further back in the events. All right, Mr. Pitts, sir, the state's charged you with trespass on property other than a structure or conveyance and criminal mischief. You've got conflict counsel. They're not present here today, but the case needs to get on a pretrial docket. Do you understand that, sir, so we can get it into court?
Yes.
Okay. They don't reset these.
No, Your Honor.
Okay, it'll just be a plea of not guilty and the matter will be set. Don't tell me anything about any discussions you've had with an attorney. Don't talk about the case or anything, but let them know, we're gonna give you a date here in court right now that we're gonna announce here in open court that the case is set for a pretrial conference, okay?
Okay.
Okay, thank you. We have Eric Wilson. Sir, your name, please?
Here, Alice Wilson.
All right, Mr. Wilson, sir, you're here on a charge, sir, as follows. The Public Defender's Office was previously appointed to represent you, and the charge that has been filed at this time is assault on a law enforcement officer.
And Your Honor, at this time, we'd enter a plea of not guilty.
Okay, the matter will be set for pretrial, sir, and we're going to give that date here in open court, okay? One little second, just let me get out of that counter. Yes. All right. Okay, I think we are ready now to do, I don't have, are they, they're not here. Okay, there they are. Okay. All right. Thank you. All right, Counsel, again, if you would announce your name for the record, please.
Mary Abraham, on behalf of Mr. Spencer.
All right. Sir, would you state your name, please?
Joe Spencer.
Mr. Spencer, sir, you are here. This was an arrest warrant. Arrest warrant was issued.
We would waive the reading, Judge, and also I forgot to mention I'm covering for Ms. Holton today.
Thank you. All right. Entitled to a bond.
He is not, Your Honor. This is punishable by life.
Judge, he's entitled to a bond because the child was above 12, not under 12. If he was under 12, he would not be entitled to a bond, but he is entitled to a bond for,
Okay, let me just hear from the state. They said he's not. It's 12 to 8, 17?
That is correct, Your Honor.
A little louder, I'm sorry.
That is correct, Your Honor. If the victim had been under the age of 12, that would have been a capital offense. But as the victim was between the age of 12 and 18, it is just a PBL, still not entitled to a bond.
Okay.
Judge, we would argue he's entitled to a bond as the child was over 12. We'd be asking for a bond in this case.
Okay, so are you saying it is not punishable by life?
I would need to pull the statute if I can have a minute to see if
Okay,
his
I'll let you have that
entitlement.
minute. Yes,
Thank
sure.
you.
And I'll have the state do the same.
Your Honor, I've already done that. I do
Okay.
know that it is punishable by life.
Okay, that's fine, everybody. She just needed to check real quick, because that's the difference, if it's punishable by life and the.
Your Honor, would you like to look at my screen to see? Okay,
Were you gonna pick that computer up?
it's a laptop.
Sorry, I didn't see that. Do you want to share that with her, maybe?
Sure.
Counsel, she's got that pulled up also over here, okay? And do you need more than a few moments to do that? Okay, then do you want to just have him step in the back and we'll keep going? How's that, everybody? Okay, thank you. Yeah, we'll call him back up. Just try to keep things moving and. Uh-huh,
Dondre is on mental health status.
okay.
And Your Honor, he does have an offer of 5 days in Orange County Jail if we can reset.
Okay, we've got also some, all right, let's do this. He's got, at this time, notification of revocation of pretrial release also, in addition to the new charge on the trespass on property after warning. I do find probable cause. So you want, how many of these are we resetting?
Your Honor, I'll be honest, there's about 10 of them that have not been cleared through mental health. It's to no fault of their own, and a bunch of them are credit time served offers. They just haven't been cleared, and it's really not their fault, and they shouldn't be punished for that.
I understand, just tomorrow's gonna be, state your position.
Thank you for asking, Your Honor. The state has no objection.
So will everybody explain tomorrow what is going on? Because it, you know, I understand. I understand the defense's request. I will hold off on signing. He's not going to bond out anyways. There's a violation. It's a hold on him, the violation of the pretrial release. So I will hold off on signing that until tomorrow. So I'm going to hand that back. We're going to hold off on that.
Are you here tomorrow, Judge?
No, that's why. Please explain that I inquired
Yes, Your Honor.
and what had occurred. So I'll hold off on signing the violation of the pretrial release, because if they plead, that good chance will not be signed, okay? So at this time, PC is found to be reset tomorrow for possible plea?
Yes, Your Honor.
Okay.
Your Honor, next was Dallas Dominique. She bonded.
Okay. All right.
Larza Anderson, mental health.
And this one's another credit time, well, this one's credit time served.
Okay. Offer, please put on the order, and is that the state's offer?
Yes, the state's offer is an adjudication of guilt, credit time served, no return to 7-Eleven at 1201 North Cimarron
That's okay.
Boulevard.
I just was,
Okay.
is that?
Yes, Your Honor.
Okay, and the only reason is it'll maybe make more sense while I'm resetting these. Offer is credit for time served, and it, just so they know.
Understood. I will just let you know the credit and
Right.
going forward.
Okay, so we'll reset for tomorrow, PC. Please explain tomorrow. Okay, the next person.
Harris Anthony, mental health.
Now, that one's a battery, so there wouldn't be an offer.
Yes, Your Honor, and there's no offer on this one, and we are ready to proceed on this one. This is a client of ours who is incompetent to proceed, or has been found incompetent to proceed in his other cases.
Okay.
And we can waive his appearance.
All right. So Public Defender Office will be appointed. The bond will remain at $500, no contact with the victim.
And Your Honor, defense would actually request that he be released on his own recognizance due to the current finding of being incompetent to proceed via
When
the
was
case.
the last, when was he last, or he last found incompetent?
The last filing in open court, or the last filing that I pulled, that I am aware of, there could have been more recent ones, is in 2021 CF.
But when is, yeah.
It's February 27th, 2023. They filed an amended conditional release order where they found the defendant was previously adjudicated incompetent to proceed due to mental health on June 14th, 2022. So that's when the case officially found it. He has been going through competency status and hearings.
Okay, so wait, just.
And I can approach.
No. I mean, I'm okay. Just in 2023, the finding of the court at that time was what?
In February of 2023, it was an amended conditional release order, and it
Okay.
just stated the previous findings and putting
Okay.
him back on conditional release.
Okay, so he wasn't found incompetent.
He was found incompetent officially on this on June 14, 2022. They just continued the findings as recently as February 27, 23.
And to the state, your position on, it's already out on ROR on another case. Okay, and that's 2023 MM257AA. And we have another charge,
Your Honor.
2023 MM345AA.
And I do have case law to provide to the state and Your Honor, which explicitly states if someone's been found incompetent to proceed, if they,
Oh, but there's a lot of case law that discusses the time frame on that too.
this is regarding release on new offenses. If they're arrested on a new law offense, they're still entitled to be released and not be held at a bond. So that was the argument I was going to be making, to release him on his own recognizance.
Okay,
No further arguments regarding dismissal of the case or anything like that.
state your position on,
Your Honor, I've not seen that
yeah.
case law, and so I would be asking for a bond.
I am inclined, we'll call it back up later on.
Your Honor, if I
Well,
can-
he's not here, so you know what?
No, he's not here. If I
He's
can
not
approach with
here.
the case for Your Honor.
Sure, yeah, he's not here. He's not going anywhere, everybody. I'm not gonna just strictly release him on ROR, I don't think so. And this was 2018, and there's a lot of case law I have on competency that I'll need to probably look at. Okay, we have Lee. Come on up, sir. What about the open? We're gonna address everything, okay? Lee, sir, your name, please?
Darian Lee.
All right, so you're here on a charge of obstruction by false information, sir. This is case number 2023 MM5070AO. I don't have where you appointed the public defender. Do you want an attorney to represent you, sir?
Your Honor, he actually has a resolution to his case today, which I believe he wishes to accept.
Okay,
The offer from the state is a withhold of adjudication credit for time served. He does wish to accept that offer and enter a plea of no contest.
okay, credit for time served and court costs. Is this the agreement of the state?
Yes, Your Honor.
All right, he's got 2 days in. Mr. Lee, sir, it's my understanding that you wish to enter a plea of no contest to the charge of obstruction by false information. Is that correct, sir?
Yes, ma'am.
Is this your signature on the plea form?
Yes, ma'am.
Did you read and understand the rights on the plea form, sir? And do you have any further questions regarding those rights that you're giving up by doing so? Are you on probation for any other matter? And do you further understand that by entering the plea today, it will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
Yeah, okay. And at this time, sir, knowing all of that, do you still wish to continue with your plea of no contest?
Yes, ma'am.
I'll accept your plea. I find sufficient facts to do so. I'll adjudicate you guilty. I'll sentence you to the 2 days you served, credit for 2 days' time served, plus court costs. They're going to add everything together, and I'll give you 1 year to make that payment. If you can't, or if you want, you can set up a payment structure with the clerk of court to start that earlier under a payment schedule, okay?
Yes, ma'am.
All right, sir. You have the right to appeal the sentence of the court, must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed to represent you. All right. Thank you, sir.
All right, thank you. Guys.
You're welcome. We have Moody, no, yeah, your name, please?
Manisha Moody.
Okay, you want to make sure I've got the right case. You're here on a charge of petty theft of $100 or more. This is case number 2023 MM 5090 AO. So let's just, you also are out on bond, you just bonded out. And I do find probable cause as to the new charge. And do you, yes, you do qualify for the public defender. I wanted to make sure you did qualify. At this time, the bond in that case will remain at $500. I'm going to require you not to return to the scene of where this occurred. Do you understand that?
No, ma'am.
I'm sorry?
No, ma'am.
She said no. I don't know what. Okay, I'm sorry, I just couldn't hear the way it echoed. Did you understand? You
Yes.
can't go back there.
Okay.
Okay. Also, you are out on bond on another case, and that is case number 2023 MM, I cannot read the clerk's writing, sorry, or not you all, that's 188AE. And you just bonded out on that case on the 13th. I don't know if you have the public defender on that case. Probably were appointed, I don't know, but I'll go ahead and appoint them on that new, or old case rather, also. This time, I'm gonna revoke that bond. At this time, you're out on bond 5 days ago, and I'm gonna set bond at none on that.
Your Honor, defense understands the court's position. However, defense would ask if Your Honor is inclined to revoke. If you can revoke and double, it appears as though the charges were not filed, they're not filed on at this time, and they are different than the new charges. And for those reasons, we just ask if Your Honor would be inclined to revoke and double.
Understanding the defense argument, but the court does find 5 days out and committing a new offense. And looking at that, the court finds that that is an appropriate resolution to that case at this time.
You appointed the public defender on the out-on?
I did.
Thank you, Your Honor.
I did. And Ms. Moody, it doesn't mean your attorney can't apply immediately for a bond hearing on that, okay?
You can do a bond hearing with your attorney, like we talked about there, okay? So you're gonna have to do a bond hearing, but right now you are being held no.
Okay.
Morrison Jermaine, he's on mental health.
Okay. See another
This is
one?
a credit time served offer, Your Honor.
All right, so you would ask that I reset it for tomorrow?
Yes, Your
also?
Honor.
Okay. Reset for tomorrow for plea, mental health, or just, you know, just everybody, I want everybody to, the judge to know why we reset these. And I'm sure it,
Ano Niwu,
gee,
he's on mental health.
that's what, you'd said there were a number when we took our break. Is the request the same on,
Yes, Your Honor. The request is the same on that one.
okay. This time, we will reset for tomorrow for plea. Is Sharead, maybe? Mr. Sharead?
Piece of cheek.
That, okay.
Yes, ma'am.
Don't talk
All right,
about
Mr.
it.
Sharead, sir, you're here on a charge of petty theft, sir. Do you wish to have an attorney appointed to help you out? Or was there an,
No, ma'am.
You don't want an attorney?
Yes, ma'am. I'm here for a 50-cent piece of cheese.
Just don't talk about the case. Your Honor, I believe he does wish to have an attorney.
okay. I'll appoint the public defender's office to help you out, sir, okay?
She's talking, you gotta
Yeah,
listen,
I just,
okay?
Thank you.
okay. All right, at this time, is there an offer?
No, you're
No, I didn't think, but every now and then I'm surprised with one. I mean, on that type of a charge, you know, at this time, bond will remain the same at $500. Don't return to where this occurred. Don't go back there, okay? All right, sir, don't go back to that Walgreens.
Your Honor, he's raising his hand because he wanted to request a lower bond.
Okay.
But I am just, Your Honor, I would just ask the court to take notice of the limited history. I don't know if Your Honor, I doubt Your Honor would be, if Your Honor would be willing to release someone on his own recognizance, otherwise if we can reduce to $100.
Let me just, I'm just looking at one other matter under this. Let me get to the right sheet here.
And I do believe the alleged item was food.
It was, that's what I was double checking. Does the state have any objection?
State would object, Your Honor. He has 2 open
Saw
cases
that.
in St. Johns County, and he also does have convictions out of state.
I saw those, there are, do you see at the bottom of the sheet, there's open cases. At this time, Mr. Sheread, sir, I'm gonna deny that request. I'm gonna keep bond the same at 500. If you post your bond, sir, make sure, though, you keep all your court dates, okay? Make sure that you keep your court dates, but you do have an attorney on the matter, and they can file any appropriate motion or review the case with you. It also looks like you've got some open cases out of St. John's. Don't say anything about it, but I just am letting you know it looks like you've also got some open cases there, okay? All right, thank you, sir.
It's with you.
We have Sims.
He's on mental health. Sims Rashawn is on mental health.
And Your Honor, this one's a similar argument as Mr. Harris, where he's been found incompetent to proceed in a previous case.
Okay, I don't know anything. We'll skip that one for a moment, okay? Well, he's not, they're not here. It makes it much, I understand the.
Understood.
And when was his last competency?
For his, Your Honor, I don't know if I went through all of his cases. The one I printed from him, Your Honor, was on March 13th, 2023, and this was the actual order adjudicating and finding, not just the release.
Okay, that's a little different than, I understand. I'll call it back up when I call the
Yes,
other
sir.
one, okay? Are we ready on your case now? Did you all sort through that?
I believe we have differences in opinions, but
Okay. Okay. All right, well, let's see what that is. Let me grab that paperwork again. So this is the Spencer matter again before the court. And at this time, counsel, you may proceed again.
thank you, Judge. Defense is going to argue that this is not a dangerous sexual felony offender. The statute when opening 794.0115
Go a little slower, because I'm pulling up this, I'm now opening up the statute book. All right, you can go ahead.
Under 794.0115, he doesn't qualify under the elements that are listed there for somebody that would be a dangerous sexual offender. There was no force, violence, anything used in this case. This was a consensual incident that happened between, according to the affidavit, between my client and this alleged victim. We would be arguing that he should qualify for bond in these cases.
Okay, all right. So he is charged under 4A, correct?
Yes, Your Honor.
All right, and that says a person 18 years of age or older who commits a battery upon a person 12 years of age or older but younger than 18 without the person's consent, which they're under the age, under any of the circumstances listed, commits a felony of the first degree punishable by terms not exceeding life. And so listed in paragraph E, and E has, let me get down to E. I think I know what the argument's going to be, but go ahead, state it this time.
Your Honor, it would, I apologize. As probable cause had already been found, I did not review this, and I know that it is punishable by life, so it would likely be,
There were two cases today, I believe, charged another case, and
this is the only one that's a PBL. The other one was lewd and lascivious molestation. I think we've already resolved,
we did, right.
addressed that case.
Judge, I'm unaware of another case.
No, it wasn't your client.
Okay.
I was thinking two similar type of cases, and sometimes the facts, we read a lot that
Understood.
if there was any merging of those, review of those facts, that's all.
Thank you.
So, I'm sorry, to the state, what is the argument then? Because it says, without that person's consent, under the circumstances listed in, and then it says E commits, in paragraph E. So where in paragraph E?
One moment, Your Honor. I am trying to open up the affidavit.
I've got it.
That's all right, Your Honor.
Got it.
Will eventually open. You wanted to be completely honest, due to her age, I would argue that she was incapable of agreeing to sexual contact.
I don't think that's the requirement under the argument that the defense, that's not what you're arguing, is it?
No, Judge.
No. She's saying that it's I don't mean to interrupt, but the enumerated offenses under subsection E, which would reclassify this to punishable by life, are not included in this affidavit. Is that correct?
Yes, Judge.
Okay.
And I will just add, my client doesn't have any criminal history
Correct.
as well.
Right. But I believe the state's argument would, maybe I'm wrong, but I just think the argument was that it is just punishable by life, period. But I believe in looking at that, there are some that are PBLs when those enumerated factors under E are included, those circumstances would reclassify this to PBL. Does the state have any other argument?
No, Your Honor. It is, none of the factors in E that I can find in this affidavit as is are listed, so it is based solely on her age.
Okay. But solely on her age talks about 12 to 18, correct?
Yes, Your Honor.
Okay. And where in the statute do you find solely on her age it would be punishable by life?
Because it says between the age of 12 and 18, Your Honor.
But you got to read the whole paragraph.
No, I understand, Your Honor, and that's why I'm saying, with regard to subparagraph E and those factors, that's not listed in this affidavit.
Okay. And where do you find, though, being 12 years to 18, that without those factors, it would be?
No, Your Honor, Without those factors, it would just be a first-degree felony.
That's what okay, all right, thank you. That's what I thought it was, but I just wanted to make sure I was following through on both the arguments. So at this time, I believe he is entitled to a bond. I understand the state's argument, but looking at those enumerated as set forth, that would reclassify this to punishable by life. Those are not enumerated in the affidavit. So as to the conditions of the bond, I'm going to make some things very clear. Do you understand, Mr. Spencer, you are to have no contact with the victim in this matter? Do you understand that, sir?
Yes, ma'am.
And do you understand that is directly, indirectly, through a friend, through a family member, texting, any social media? No contact means absolutely no contact. Do you understand?
Yes, ma'am.
All right. Do you understand also that you are not to return and have no return to the scenes of where this occurred? I mean, I know there were different areas, but you understand you're not to return to any scenes of where they occurred. And you're also not to have any contact with any of the state witnesses, because I think there's going to be some family members that are also probably giving testimony also. At this time, sir, I'm going to set bond in the amount of $7,500 under count 1, and I'm going to set bond at $7,500 under count 2, with those as the specific conditions of your release. Okay? And was there any other conditions that the state would request?
Your Honor, I would ask that he have supervised contact with any minors.
I think that's probably fair to ask. At this time, sir, I'm going to require you, under the age of 16, that you are required to have no unsupervised contact with any minor under the age of 16, okay?
Yes, ma'am.
Okay, sir. Oh,
Your Honor, would the court be inclined to maybe on count 2, lower it to 5,000 just so it's a bit affordable?
I'll deny that request. I understand the request, but I'm going to deny it at this time, okay?
And Judge, just to preserve for the record, defense would object to state's request for no contact with minors, understandably. Thank you, Your Honor, that's all I have. May I be excused?
Okay, thank you. You may be, thank
Have a
you.
good day.
Good seeing you. All right. So you can go.
Here's your bag. Your Honor, we're gonna, Volsey, Alon,
Okay,
he's on mental health.
This is another credit time served offer.
I'm sorry, what happened with Theodore?
Oh, I'm sorry, he's been going since 4 o'clock.
I'm- Okay, gone, okay. That was Theodore? Yeah. Okay, so now we have Voley is what we were on?
Volsey, yes.
Okay. Oh, Volsey, sorry, I need to read writing better, don't I, on some of these? All right, and so you are asking for that to be reset?
Reset,
for
yes, Your
tomorrow,
Honor.
hopefully. I won't take any action on the out on bond, you know, because if it's resolved, that'll be.
Thank you, Your Honor.
You're welcome. And PD will be appointed. Request, you know, please, yeah, just make sure they know, please. Are we getting close to that being all of the resets, maybe?
Possibly, I'd have to look before I gave you an
All right,
correct
we'll
answer.
keep, all right. Your name, please?
Glenn David Wells, second.
All right, sir, you're here on a charge of trespass on property after warning and possession of drug paraphernalia. And you do qualify for the Public Defender's Office, so I'm going to appoint them to represent you. And at this time,
And, Your Honor, the state has made an offer of an adjudication of guilt, credit for time served, no return to the 7-Eleven at 9562 East Colonial Drive, and he does wish to accept that offer and enter a plea of no contest.
and as to count 2,
To run
credit for time served also.
run concurrent,
Okay.
as long as nothing else is holding you, you'll be released today.
Sir, it's my, and is this the agreement of the state? I'm sorry.
Yes, Your Honor.
Okay. Sir, it's my understanding you wish to enter a plea of no contest to both the trespass on property after warning and the possession of drug paraphernalia. Is that correct?
Yeah.
Is this your signature on the plea form?
Yeah.
Counsel, I need you to sign the plea form.
Oh, I apologize.
Sorry, have we
I
been?
usually don't sign them if we haven't been appointed yet, and only sign if we
Oh.
have been appointed.
He's got the affidavit filled out.
I can sign it, Your Honor, and I can sign them going forward. That's just
I
usually.
think there was, I think the only other one were the arraignments, because we've reset, yes, tomorrow for them. All right, sir, at this time, once again, you want to withdraw a plea of no contest to both the counts, is that correct? Is that what you want to do? I've got to have you,
You gotta listen to the judge.
What?
okay, I've got to have you respond. We're being recorded.
Okay.
So I need to ask some questions about the plea form. It's my understanding that you wish to plead no contest to both the trespass on property after warning and the possession of drug paraphernalia. Is that correct?
Yes.
Is this your signature on the plea form?
Yes.
Did you understand the rights you're giving up by pleading here today?
Yes.
And do you have any other questions regarding those rights that you're giving up?
No.
Are you on probation for any other charge?
No.
And do you understand that by entering a plea today, if you're not a U.S. citizen, it can subject you to deportation, or it would subject you to deportation? All right. And at this time, Mr. Witz, at this time regarding those two counts, do you still wish to enter your plea of no contest?
Yes.
I'll accept your plea. I'll adjudicate you guilty. I find sufficient facts, based upon the police report to take the plea. I will sentence you to 2 days in jail, credit for 2 days' time served. You'll be released under this case today. There's mandatory court cost. You're not to return to the scene of where this occurred at 9562 East Colonial Drive, so you cannot go back there. And I will require you to pay the court costs, and I will give you 1 year to make those payments, okay?
Okay.
All right, sir. Now, don't go back to the 7-Eleven, you understand?
Okay.
All right, sir. I previously advised you of your right to appeal the sentence. Thank you. He's out. All right.
Yana Young, Stephen,
Yes?
mental health.
Your Honor, if we can reset, this is a credit time served offer.
Are you going to be here tomorrow?
Ms. George will be here, and I have informed her and apologized already.
And we know you're going to be here.
Yes,
Yes.
Oh, is it going to be Ari, actually?
yes.
Oh, Ari, our manager's covering. I'll let her know as well.
Sorry.
It's par for the course. No, I totally understand.
I know. All right, reset for plea tomorrow. Okay. Okay, then I can sign these. These were the pleas I took. No, these are pre-trials and, all right. Okay,
Atwell, Kamisha, she's on mental health.
all right. That was a failure to appear, so that failure to appear for a competency hearing. So
Yes,
that-
Your Honor, even if there was an offer. Yes.
And,
And there is conflict counsel on this case, Your Honor.
okay. That will remain at no bond, and I'm sure they'll get that set up pretty quick for a competency hearing, I'm sure, or for a hearing. So it remains at no bond. Okay,
Yana Pullins, Shelley Pullins,
yes.
she's bonded.
Can I get a few things in order, everybody? I apologize, I want to make sure I'm. All right. There's that. Okay, we have Brown.
He's on mental health, Your Honor.
We can waive his appearance if you appoint the public defender. There's no offer to resolve.
There's not, okay. At this time, Public Defender's Office is appointed, the bond will remain the same at $250, okay? We then have Shelton Donald.
Your Honor, I apologize. Before we move on from Brown, I think there's also a violation of probation.
Oh,
Yes, Your Honor, there is. And I don't know if you stated a finding of probable cause.
no, I don't have it in my hands. Let's see. It shows it's an add-on, but I don't have any paperwork. Madam Clerk, do you all have paperwork for that VOP?
22
Brown?
CF 500.
No, we don't show it.
Okay.
We only have the disorderly,
It'll be addressed sooner or later.
okay? It'll be back, I'm sure. So at this time, once again, does correction show that?
I thought I had the VOP for today.
Did you? Everybody thinks they have it, or everybody does have it. They don't think. You all know you have it. We don't.
I have 2 case numbers.
You want to go ahead and print that out then? So there was actually an arrest affidavit and,
I'm sorry? 22 CF 500.
waived, they, PD appointed, PC found
That's what's
250.
AA maybe? It's not.
It is not Orange County.
We don't, that's why, it's not Orange County. So, all right.
Anyway.
I'm sure they'll put it on the docket if it's not, I mean, if they,
It might have been an on-site violation because I do have the affidavit. It says, yeah, by committing, I believe it was an on-site, Your Honor.
okay, on
So
view.
the arrest that we're here
Right.
for, that's what they used.
Yeah, but the clerks are gonna need, I mean, I'll take it, sure, I don't know if they have paperwork. Oh, yeah, it doesn't have a case number or anything. I mean, I'm looking at the top for the clerk's information. Yeah, it shows an on-view violation. You all probably need to have that. There's, that's the paperwork. It doesn't have a case number or anything on it. That's, I think it'll be here tomorrow, everybody. Okay? They have it on today? Do you have like a case number, that document you gave them? There's no,
2022 CF 0005008.
okay. All right, so it's an on-view violation of probation. Said Hillsborough County. Okay, court finds PC. And bond will remain at none at this time. And the PD's appointed on our disorderly. Okay. I'm sorry, Shelton Donald.
Your Honor, if we can reset this one, it is a credit time served offer.
Reset for plea tomorrow. We have a camping, and the state agrees to all these pleas that we'll be able to resolve.
Yes, Your Honor.
Okay, thank you. Barry McMongal.
Your Honor, if we can reset this, it's another credit time served.
Offers again, credit for time served, reset for tomorrow. Oh, gosh, I name, ooh, it's not gonna be a happy name tomorrow. Your name, please?
Can't tell her.
What's your name?
Anthony Rivera.
All right, Mr. Rivera, so you're here on a charge of disorderly conduct, sir. I will appoint the Public Defender's Office to represent you, sir, at this time. And this is case number 2023 1032AO.
Man, why can't we resolve this today? Because
I think you're on
it's all the time.
probation. Okay, let your attorney talk to you.
State hasn't what they're saying is that they're on probation. The state hasn't made an offer, and we'd have to look into that, but they're showing that you're on probation.
Because it does appear that he is
Out
on
of
probation.
prison. I just got out of prison.
Probation.
Your Honor, if we can appoint the public defender and give him time to speak with an attorney on this one.
I will. I've appointed you
So I
all.
gotta
to
sit in this jail
qualify.
for.
Bond will remain at 250.
You have a bond of 250, and also
Yeah.
everything you say is being recorded, so
You know, man gave me a bottle of
don't
water.
please stop talking.
This is all I can.
Don't,
Stop
she
talking.
doesn't want you to talk about the case, okay? Because she doesn't want it to be used against you, no matter what. You may think what you're saying is helping you, but it's like, even if you say something as simple that you're
I'm
saying.
guilty, so I can't
Please.
go home.
Okay,
Well, how much time are you gonna give me? I'm guilty.
You're on probation.
okay. You're on probation.
No, I'm not on probation.
okay.
Okay, well, that's going to give them time to review it, sir.
You want to keep me locked up so you can make money off me? That's all your system does.
Is the bond 250 still?
Yes, you got a bond, sir. Okay. We have the next case of Robert Shanks.
Sign it.
Okay, yeah. Yes. This is what we talked about.
All right. Sir, your name, please? Mr. Shanks, could you tell me your name?
Robert Joseph Shanks.
Okay, I just want to make sure I've got the right person in front of me. Sir, you're here on a charge of disorderly conduct. And at this time, I'm showing that you qualify for the public defender. And at this time, how is your client wishing to proceed?
Yes, Your Honor. The state has made an offer of an adjudication of guilt, credit for time served, and he would like to enter a plea of no contest and accept that offer.
Okay. At this time, is this the agreement of the state?
Yes, Your Honor.
Mr. Shanks, sir, it's my understanding you wish to plead no contest to the charge of disorderly conduct. Is that correct, sir?
Correct.
Is this your signature that's on the plea form, sir?
Yes, ma'am.
All right, and did you understand the rights you're giving up by pleading here today?
Yes, I do.
Are you on probation for any other matter?
No, I'm not.
And do you understand that if you're not a U.S. citizen, it will subject you to deportation if you enter a plea to these criminal charges and you're not a
I'm
U.S.
a U.S. citizen.
I understand, sir. I'm just required to advise everyone of that, okay? Also, sir, you understand that by pleading no contest today, we're going to resolve the charge against you?
Yes, yes, ma'am.
Okay, sir. At this time, I'll accept the plea. I'll sentence you to do the 2 days you served with credit for the 2 days' time served. You'll be released today on the charge.
Thank you very much.
And there are mandatory court costs. What they're going to do, or what I'm going to order you to do, is pay those within 1 year. If for some reason you don't believe you can do that, get down to the clerk's office well before that and start a payment plan of something that you can afford, okay?
Thank you.
All right, you're welcome, sir. I previously advised you of your right to appeal the sentence. Thank you.
And Your Honor, for the next one, there is a probable cause argument.
Okay, and that is for disorderly conduct
Yes, Your Honor.
on John no.
Yes, Your Honor.
Yes, okay.
He had an argument.
All right, he was arrested. Okay. Sir, your name, please?
Welter, John Welter.
All right, and at this time, Public Defender's Office is appointed, and the charge at this time is a disorderly conduct, and you may proceed, counsel.
Yes, Your Honor. Per the statute and law regarding disorderly conduct, to meet that, they have to, it reads that any person who distributes any material to or receives any object from an occupant of any motor vehicle, and it carries on from there. However, the rest does not apply to my argument. The argument I'm making here, Your Honor, is if you review the police report, it appears as though an ambulance pulled up, and the police report states that he retrieved an item from inside the vehicle. However, it doesn't say that an occupant gave him that item. This is an ambulance. We don't really know what was happening, if he was seeking medical help, if they were checking on him, if it was a wellness check, things like that. So based on the four corners of the report, the way it's phrased, the way it's stated, I don't see that there's probable cause to show that an occupant from the vehicle gave him something. And for that reason, we would argue there's not enough probable cause for disorderly conduct because it's clear that an occupant has to give them something.
State.
Your Honor, it states that the ambulance was stopped at a red light. Therefore, no, the ambulance was not there for him. It was stopped at a traffic light. And as it's an ambulance, Your Honor, unless the defense is saying that he broke into the vehicle and took something, then an occupant gave him something out of that vehicle, Your Honor.
Okay. Just a side note, not my probable cause determination. I'm curious if they gave him water out of the I don't know. It does. I'm just, we're talking an ambulance that, we know what an ambulance does, assists people, helps people. I agree with the state. They're at a traffic light. It is stopped. An ambulance is covered, and it's not an open flatbed. It's a van that is covered. But I also find it interesting that what did they maybe give him to help him with? I understand. I do find PC, but at this time, I'm going to ROR him. Okay, I know he's out on bond, so let me talk about this. Now, Mr. Welter, I know you seem very excited that the court did this, and I mean, that's fine, I get that. But let me just tell you, sir, you're now out on 2 disorderly conduct, sir. I don't know anything about the first case that you were ROR'd on. But, sir, I suspect if you come back in again here with these open cases, the state is surely going to remind the court that's handling that you are out on 2 RORs and to revoke both of those. You understand, sir? Okay. And stay in contact with your attorney. And I don't know what that item was. It's be interesting to know what it was they handed him and if they were assisting him.
Are we done?
Yeah, we're done.
Stay in touch with your attorney.
Where's the pen?
Don't, please.
The attorneys want to approach, please, real quickly, and any objection going off the record? Just, can you come up for a moment, both of you? Any objection going off the record? Your last name?
Sims.
Okay, Mr. Sims, sir, you're here on a charge of no valid driver's license. At this time, sir, I've reviewed the charge and affidavit, and I find probable cause. I'll appoint the public defender's office to represent you, sir, and the bond is set at $500, sir. You're not to drive without a valid license.
Your Honor, there is an offer to resolve the case. However, in the alternative, it does look like he has no history to limited history. I apologize. I'm trying to get to his space sheet to confirm. It looks like he has limited history, Your Honor. The state has made an offer of a withhold of adjudication credit for time served. He is seeing if Your Honor would be willing to release him on his own recognizance so that he can work on fixing and obtaining his license. So if Your Honor is willing to, we'd ask that he be released on his own recognizance for that. If not, he does wish to resolve his case.
Okay, any objection on behalf of the state?
No objection from the
I agree. I looked at his face sheet and his other matter. Mr. Sims, sir, I'll go ahead and ROR you, sir, so you can try to get the license taken care of, sir. Just to understand, though, sir, you cannot drive without a valid license, okay? And that's without objection from the state. I'll ROR. Okay, thank you, sir. Stay in contact with your attorneys, though. You're going to get a date to appear back in court, you know, for that, and it's usually pretty quick on those traffic offenses. Sometimes it's a couple of weeks.
Good luck.
Okay, I believe we are now on the felonies. Is that correct, everybody?
Yes, Your Honor.
Yes, Your Honor, we made it.
Yes, then we have the 33-day motions too. All right, your name, please?
Mine?
Yes.
Miss Allsod?
All right, Ms. Allsod, you're here on a charge. This was a failure to appear in case number 2018 CF 6088AO. The court in that division issued a warrant set bond at none. Are you hiring your own attorney, or did you have a private attorney?
I do not have an attorney.
Your Honor, it looked like prior to going into diversion, she had conflict counsel.
I don't know, do they stay on, and there was no withdrawal on that? I hate her not having somebody, even if you all have to withdraw again.
Your Honor, if you want, I'm sure you can appoint us and we can withdraw again if.
Yeah, because I don't know, I know in misdemeanor, a lot of times they file the motion to withdraw once, or conclusion of the case.
Don't know if they did.
I
I didn't
did in
check
this
for that.
case. How long has she been in diversion? Does anybody know what that?
I I'd have to check with the state.
Your Honor, I don't believe she is in diversion as she was set to plea back in 2020.
Okay.
I think at some point it got kicked out. I don't know
Okay,
when.
when was set to plea then. I'll go ahead and, they didn't withdraw, active KPS. I'll keep conflict counsel since they were the ones that were appointed. Ma'am, you need to contact the office, you know, you're shaking your head, yes, conflict counsel. It'll be set, but they need to know that you did get picked up on it, okay? All right. I thought it was a diversion, but I see that it.
I believe it was diversion,
Right,
then
then it
plea.
got
I
kicked
apologize,
out.
I skipped some
That's all right. I know what you mean. It got pulled back. So conflict will remain involved. Okay. All right, thank
You're
you.
gonna have to talk to your conflict counsel attorney.
Sir, your name, please?
Fred Blanc.
Mr. Blanc, sir, you're here on a few cases, sir, and let's go ahead and go over those.
Okay,
Your attorney probably doesn't want you to say anything. Let me get you an attorney appointed, okay? You qualify for the public defender's office. I'm going to appoint the public defender's office to represent you. All right, so you have a public defender appointed. You're here on the following cases: 2022 CF 14077A0, and in that case, the court had issued a warrant for failing to appear for a plea hearing. That bond has been set at 0, and that will remain at 0. You have new charges as follows: driving while license suspended, and then a second case of resisting officer without violence. At this time, sir, I find probable cause to both of those, and bonds will remain the same at 500, and, or both of those are set at 500 each. You are also out on bond on another case, driving while license. No, wait. You got another, that's true. You got another active case, possession of MDMA, ecstasy, and resisting officer without violence. And at this time, sir, the PD's appointed on that. The bond will remain the same at 1,000 and count 1 and 500 under count 2. You're not to possess or consume any illegal substances, and you are currently out on bond under case number 2023 CF 3456AO.
and ma'am, that's, I'm out. They messed up. That's not me. The birthday is May 25th. May 25, 1985. I was born in 82.
Okay, hold on. Well, sir, they're showing that case number, 2023. Well, you're in on a no bond on another case too, so you're saying that the out on bond is not you?
No. The add-on bond is me,
The
but
2022 case.
there's, there's
I got it.
the warrant,
You don't-
that's not me.
We're looking at it.
Well, I can tell you, the one that you're out on bond on, sir.
That's me.
Oh, okay, well, yeah, I
You don't
know.
have to say
I mean,
anything.
I just don't want you to say anything to be used against you.
Sorry.
sir. That's okay, I just don't want it to be used against you. I'm gonna revoke that bond, and I'm gonna set that bond at none, okay? Because you're out on bond and you picked up new criminal charges. But you're saying that the warrant that was served on you is not you?
No, ma'am.
Okay, sir. Then I will have them, correction show. You know, we usually have booking photos. I know usually there's and the address is the same. Sir, this time, you're in on the no bond on the other one, on the capious one, sir. I'm going to just give the attorney just 1 second. I'm going to look up one other matter, too. Does the state have any other information or the defense? I'm not showing anything that I can, the defense can file. I've got an attorney appointed on it, sir, okay, just to assist you on it. Also, for identification.
I don't know that that's something we can resolve here, Your Honor, because I think they would have to do fingerprints and what have you. So I don't, I think.
I agree. I don't think I can resolve it today just on that own information. That's why, sir, I've got you a public defender appointed on it, on all the cases to assist with that. But at this time, sir, based upon the warrant that I'm seeing and the date of birth and the address and the information, sir, that warrant was served on you. And your attorney will write notes, I'm sure, and get that information to their office, but bond is set at none on that case also, okay?
And you revoked the out on bond?
I did. So they're gonna look into that for you, okay?
Let's talk in more detail, okay? Let's talk to your attorney in more detail, but now you're being held no bond on 2 of them.
And I don't know if you want to do a motion for Prince in that you'll know, I'm sure.
I'll let his attorney know.
Yeah. Your name, please?
Bonner Roy.
Mr. Bonner, sir, you're here on the following charges, sir. You're out on bond. First of all, on 2 cases, CF 2023-8112AO and CF 2023-7477. And you've picked up a new charge of possession of amphetamine and a charge of possession of cocaine, sir. I'm going to appoint the public defender's office to represent you on the cases, sir, at this time. I do find probable cause. At this time, sir, I'm going to revoke the 2 bonds or the 2 cases that you're out on ROR'd on. I'm going to revoke those and set bond at none. As to the new charge, sir, the bond will remain at the amount of $1,000. And the second case, that bond will also remain at $1,000, the possession of cocaine. You're not to possess or consume any illegal substances, okay? But you've got the PD appointed under all the cases.
In your honor, no information has been filed on the out on bonds. For that reason, we would just ask if your honor is inclined to revoke, you revoke in double instead of set at none.
I'll deny that request. She's been out about a month now, and I'll deny that request. All right. Thank you, sir. But the attorney can file any appropriate motions. So you've got an attorney on all of them now.
Your honor, for the next one, I just have an argument for the carrying a concealed weapon portion.
Okay. All right. Your name, please?
Drager Brown.
Mr. Brown, sir, you're here on 3 counts. 1, grand theft of the 3rd degree of a firearm, carrying a concealed firearm, possession of cannabis less than 20 grams. At this time, sir, you do qualify for the public defender. You also have a 2 other charges under 2023 CT 1145AW and 1146AW, reckless driving and driving while license suspended. And, oh, he doesn't qualify for the public defender.
How much do you make?
Yeah. Sir, how much do you make every week or every other week? How much do you make?
$15 an hour, and every 2 weeks it average out to be $1,200, $1,300.
Okay, do you have any dependents?
I have 3 children.
How many?
3.
3, okay, you would qualify. So I'm gonna change your document that shows 0 dependents. You're testifying that you have 3, right?
Yes, 3 kids, 3 children.
3 children, okay. Per testimony. Okay, then you would qualify. Is that correct, Madam Clerk, now? Okay, I'll let you, I guess I shouldn't be writing all over your paperwork. All right, and you had argument to make.
Your honor, it's just regarding the carrying a concealed weapon. If you review the police report, the police specifically state that it was only partially concealed, arguably not a concealed weapon. And we would just be arguing there's not enough probable cause for the concealed portion of that.
Okay.
Yes, Your Honor, it does say it was partially concealed under several items which appear to be concealing the firearm.
I'm sorry, I didn't hear you.
I apologize, Your
That's
Honor.
okay.
Yes, the paperwork does say that it was partially concealed. I just lost it. Partially concealed under several items which appear to be concealing the firearm.
Correct.
I don't know that it has to be totally concealed, Your Honor.
Defense would just argue if it's partially, then it isn't concealed because they can identify it.
Partially concealed. Partially concealed. I'm going to agree with the defense. Partially concealed. Are you requesting additional time?
No, Your Honor.
Chance? All right, I find no PC as to count 2. I do find PC, though, as to all the other counts. Bonds will remain the same at 1,000. State's not requesting additional time for PC as to count 2. And count 3, bond will remain the same at 500. And in addition to that, under the reckless driving, it'll be 500. And count 2, driving while license suspended or revoked rather, will also be 500. Now, I'm going to order some specific conditions, sir. First of all, you are not to possess any weapons or firearms. Do you understand that? All right, sir. I'm also going to require you not to drive without a valid license. Do you understand that?
Of course.
Okay. Well, and I'm also going to require you not to possess or consume any illegal substances. Do you understand?
Yes, ma'am.
Okay, sir. Stay in contact with your attorney and, okay?
So does your bond stay in touch with us, okay? Good luck.
You know. No. That was ROR. Yeah. Your name, please?
Giselle Camacho.
Camacho? Ms. Camacho?
Yes.
Okay, Ms. Camacho, you're here on a charge of possession of fentanyl and possession of drug paraphernalia. At this time, you do qualify for the public defender. I'll appoint the public defender's office to represent you on the case, on the matter. Bonds will remain the same as stated. I do find probable cause 1,000 and count 2, 500. You're not to possess or consume any illegal substances, okay? Thank you.
In touch with us if you find out, okay?
Thank you. I'm sorry, did I do that one? Okay. I took care of that. Okay, great. I just thought, oh, I slid it under you. All right. Your name, please?
Jimmy Christian.
Mr. Christian, sir, you're here on a charge of petty theft with prior convictions. Probable cause has already been determined. You do qualify for the public defender, sir. I'll appoint the public defender's office to represent you. At this time, sir, you're not to return to the public or have any contact with the victims. Bond remains the same at $3,500, okay?
I just asked a simple question.
You might want to ask your attorney for, just because we're being recorded. There's Ms. Camacho. You don't want my mess there.
Is this like last week or something?
Your Honor, if I could just have one moment. Give me 1 second. The 14th. Thank you, Your Honor.
Okay.
That's what it's saying, the 14th.
What did we do with that Mr. Boner case? Remember, just as long as we took care of it, do y'all remember what we did? B-O-N, I think it was, Bonner, B-O-N-N-E-R. Because that piece of paper was just sitting there, and that's what worries me about it. All right, your name, please?
Stephen Golden. Stephen Golden.
Okay, what happened with Mr. Cone? Okay, thank you. Mr. Cone bonded. Uh-huh. Phil's. I've got F-I-L-S.
You have a booking number, Your Honor?
I don't have that one, okay?
Yeah,
Okay, we're gonna handle yours in a second.
let's just skip and go to Golden. I don't know. Mr. Golden, is that correct?
Yes, ma'am.
Okay, sir, I've got paperwork that, we're not sure where some of the other people are. So we're gonna figure that out. We're gonna check on him. Did you have that next one, F-I-L-S?
Do you have a booking number?
No, it's just not this, I don't know, I'm asking corrections where he is and,
But his inmate number is on here. It's 2301-8851.
maybe
Post the
bond.
bond.
He bonded?
Yes.
Okay, thank you. Sorry, it's just if I don't go in this one order, I don't know where people are. Okay, Mr. Golden, sir, you're here on a charge of grand theft of the third degree, and at this time, sir, I will, and then you have a second case of operating a motor vehicle without a valid license, or rather, driving while license suspended, and you have a, that was it. You had those two charges. I'll appoint the public defender's office to represent you, sir, on both of the cases. At this time, sir, I do find probable cause. Bond will be remain the same at $2,500 on the grand theft, and it will remain at $500 under the driving while license suspended, okay? You're not to drive without a valid license.
Yeah,
Okay.
my place burnt down. I was just trying,
You don't, okay, you don't want to say, I don't want anything to be used against you at a later
I
time.
didn't know.
Yeah.
And you can talk to your attorney.
Okay?
And you do now, you have the public defender's office.
Yeah, I gave you an attorney, sir. Yes, sir, I appointed the public defender's office to help you on the matter.
That's the one she referred to. Yeah.
Your Honor, Hall is mental health.
Okay.
Your Honor, we can waive his appearance.
PC was previously found, and I think part of the problem is these are attached. Maybe. All right.
Bond remains at 500?
It does, yes. And PD's appointed.
Yes, please, thank you.
Henry Nicholas refused.
Okay.
Same thing, we can waive his appearance if you appoint the public defender.
I think that I gave these back, y'all, they got stuck together. All right, public defender's office is appointed. Bond will remain the same at $5,000. No weapons, no firearms, and no contact with the victim, and that's on Mr. Henry, 2023 CF 9586AO, okay? Then L.Y., Lee. Mr. Lee, sir? Mr. Lee, sir, you're here on a charge, sir. Excuse me. You're here, sir, on a charge of grand theft of the third degree. This is 2023 CF 9606AO. It was an add-on that they've added on. I'll appoint the public defender's office to represent you, sir, at this time on this case. And at this time, sir, bond will remain the same at $500, okay?
Yes, Your Honor.
Thank you, sir.
Your Honor?
Yes.
Can it be a no contact and no return?
Yes.
I believe this happened at his aunt's house.
You're not to return to where this occurred and have any contact with the victim in the matter, okay?
Yes, Your Honor.
All right, thank you.
Just to confirm, Your Honor, I understand that this is an add-on, so has
Yes.
23 CF 6038 already been addressed?
All our cases that I don't have. I have 9606. Do you have
Okay.
another case?
Pretrial? Has it already been addressed?
I'm checking.
Thank you.
Just hold him for 1 second. Sorry, y'all, I've just, everybody.
No, I
there's a-
totally understand.
Oh, no. I'd rather you ask than just sit quietly and then,
Do you see it? The
It
second?
looks like they just have him scheduled for a pre-trial conference.
Okay.
is that okay?
It's already been addressed then. Okay.
Okay.
Yeah, we're good?
We're good? We're good.
that.
We're good.
Now
All
we're
right. Okay, hang on one little second. I will lean over that way and let me get these individuals all taken care of. And Henry, Lee.
Looks like.
All right. Oops, you can take, oh, great day alive. You can take all those. Here's more. Your name, please?
Hang on, let's see.
DeAndre McFadden, ma'am.
Mr. McFadden, sir, you're here on a charge of possession of methamphetamine. I will appoint the Public Defender's Office to represent you, sir, on this matter. At this time, sir, I do find probable cause. The bond in that case, sir, is $1,000. You're not to possess or consume in any illegal substances. You were currently out on, wait, there's a second case. There's also a second case of MO 23-1035AO. That is an alcoholic beverage open container. I find probable cause as to that also. Bond will remain at $250 as to that case, sir. You've got the Public Defender's Office appointed on both of those. You were out on bond for a charge of fleeing and attempting to elude, or you were out on pretrial release. Let me look at his face sheet. I'm showing it's still an open case, sir, the fleeing and attempting to elude. At this time, sir, I'm going to revoke that pretrial release and set bond at none. You'll have to go in front of that court to request a hearing on that matter, sir, but at this time, I'm going to revoke that and set bond at none.
And Your Honor, defense understands the court's position, but would just point out that no information has been filed on that out on bond. It was on pretrial release. If Your Honor would be so inclined, we'd ask that you revoke and set a bond.
I don't know the facts of how it originally was on pretrial release. It just shows pretrial release. So based upon the history that the court has in front of me today, I'll deny that request, okay? And obviously, Mr. McFadden, sir, it doesn't prohibit your attorney from filing a motion for bond immediately on that case, sir, okay?
And just in case, can we be appointed on that out on bond if we aren't?
Yes, yeah, And on two corrections, it says revoke conditions of release on separate order. There's no, well, two corrections. There's not a revoke and set bond or revoke no bond. You'll write that on there. Okay, great. Okay, I'm sorry. Can you? Okay, so then. There's that. Now you want me to do? Mm-hmm. And then no drugs. Okay, your name, sir?
Vincent Moore.
I'm sorry, what was your last name?
Vincent Moore.
Moore. All right, Mr. Moore, sir, you're here on a charge of battery, having a prior conviction, sir. At this time, you do qualify for the public defender. I'm going to appoint them. I'm going to appoint them to represent you on the case. I'm giving you an attorney, sir. Bonds, I do find probable cause. Bond will remain the same at $2,500, sir. You're to have no contact with the victim and no weapons or firearms. Do you understand that, sir?
Yes, ma'am.
Okay, sir. You've got an attorney appointed. The case appears to be in division, I can't read, I think it's 10? 10. Okay? All right,
Ma'am.
thanks.
It's with you. Stay in touch. Good luck with everything, okay?
Your name, please?
Hermano Resto Garcia.
Sir, you're here on a charge of, a probable cause, rather, order was already issued, an arrest warrant for your arrest on this charge. It was petty theft, having two prior theft convictions. This allegedly occurred, you don't need to say anything about the facts, but at the Home Depot, just so you'll know.
Okay.
Okay? You do qualify for the public defender, so I'm going to go ahead and appoint them to represent you on the case, sir. Bond will remain the same at $2,500, and you're not to return to the scene of where this occurred. Okay?
Thank you.
You're welcome, sir.
Can I ask you?
You may want to ask your attorney first.
Your Honor, Richmond, Andrew is mental health.
Okay?
Your Honor, we can waive his appearance if you appoint the public defender.
I'll appoint the public defender's office. He's out on some bonds too, so I'm going to go ahead and address those also. At this time, in fact, I think one has 9 counts, one of the burglary charges. At this time, as to the new charge, I do find probable cause. Bond will remain the same at $4,000. Count 1, $5,000 under count 2, not to possess any firearms or weapons or ammunition. And public defender's office is appointed. As to the 2 out on bonds, 2022 CF 12876AO and 2022 CF 6376AO. I'm going to revoke those bonds and issue our PD's appointed. Bonds will be set in the amount of none. Okay. You're welcome.
Rodriguez, bonded.
Okay.
Torres, refused.
And if you appoint the public defender, we can waive his appearance.
This time, Mr. Torres, it was affidavit, an arrest warrant. Probable cause has previously been found. Bonds will remain the same, $15,000 under count 1. Count 2 will be $1,000. Do not return to the
Your Honor?
scene.
I apologize. On Torres Cardona?
Yes.
And you said the first bond is 15,000?
Yeah. Am I, Carlos Torres Cardona?
Can you give me the case number, Your Honor?
Sure. 2023 CF 9641AO.
That would be it. That's not the one that I have. Okay.
Is that okay?
Yes, Your Honor.
Okay, I
didn't
just want to
have
make sure we
that.
have the right. In PC was already, it was an arrest warrant, so bond will remain the same, $15,000 under count 1. Count 2 will be $1,000. No return, do not return to the scene, no contact with the victim, co-defendants or witnesses, and that was signed when the warrant was issued, and public defender's office is appointed. I added that at the end, sorry. I should have added that at first, didn't I? Okay, we then have Mr. Van Buren. Okay, Mr. Van Buren is out on bond for battery, just was released about 8 days ago.
And Your Honor, if you appoint the public defender, we can waive his appearance.
I'll go ahead and appoint the public defender's office. As to the new charge, 2023 CF 9627AO, I do find probable cause. Bonds will remain the same at $2,500 under count 1, $150 under counts 2. No contact with the victims and no return to the scene. At this time, I will also revoke the bond under 2023 MM 4437AO. I'll appoint the public defender's office if they were not previously appointed on that. Bond will be set in the amount of 0 as to that charge, with no contact with the victim.
And Your Honor, for the next one, Mr. Walker, I just have an argument for PC.
Okay. Mr. Walker, will you state your name, please?
Joseph Lee Walker.
Mr. Walker, sir, you're here on a charge as follows, 2023 CF 9643AO. The charge is tampering with evidence, and the second count is possession of cocaine with intent to sell. And I will appoint the public defender's office to represent you, and there was an argument that was wished to be made?
Yes, Your Honor. The probable cause argument is with regards to the intent to sell portion only. We'd be arguing that this is a simple possession. The only thing the officer and the police report rely on to say this is intent to sell is the large amount. There seems to be no other additional information to collaborate that, nothing like money found, no scales, no baggies, unless defense has overlooked that, and for that reason, we would argue this is just a possession.
Okay, state.
No objection, Your Honor.
Without objection from the state, I will find PC as to possession of cocaine. As to count 2, as to count 1, I do find PC. Bond is set at $1,000 under count 1. It's out on bond for the same type of offense. As to count 2, I will set that bond in the amount of $7,500. And at this time, Mr. Walker, you need to understand you're not to possess or consume any illegal substances. As to the charge you are out on bond, sir, I will revoke that bond. That's in 2023 CF 6249AO, and I will set bond in the amount of none, sir. I will appoint the public defender's office to represent you. If they were not previously appointed, I'll appoint them for them to be able to review the case and request any appropriate motions from that. Okay? Thank you, sir. And then
And Your Honor, I didn't check if that one had an information file, but for the same reasons previously stated, we would just ask if Your Honor instead would be inclined to revoke and double.
At this time, understanding, of course, the defense's argument, I'll deny that request at this time, noting that he was out on bond. And in addition to that, looking at the prior history, and let's see, we've got 1, 2, about 4 prior.
Yes, Your Honor, he's aware.
I just like to
No,
explain why. You know,
I do appreciate it.
I do look, is what I'm trying to.
I very much appreciate it, Your Honor. Thank you.
You're welcome. No, and I understand your arguments. Mr. Willis, is that correct?
Yes.
All right, Mr. Willis, sir, you're here on a charge of possession of 20 grams or greater with a weapon of cannabis. Let me rephrase that. Possession of cannabis over 20 grams with a weapon. Count 2 is possession of cannabis greater than 20 grams. Count 3 is possession of drug paraphernalia. I will appoint the public defender's office to represent you. Now, what is this?
I'm not sure why it came in as no bond.
Oh, and then there's a second case of grand theft of a motor vehicle, and they did a bond correction. In other words.
So I do have a bond?
Well, we're going to address, we're getting ready to address all the bonds on this. As to the grand theft, it was corrected to 2,000, so that'll remain at 2,000. You have the public defender appointed, and that was in case number 23 rather, CF 9626AO. As to the 2023 CF 9625AO, the no bond?
It's because it's with a weapon, Your Honor. However, he is entitled to a bond.
I agree. I just didn't know if there was something that, any additional information to state that. Okay. Sir, you need to understand, go ahead. Did you want to finish talking to him?
Your Honor, I'll explain to him in just a moment.
Can I speak?
Your Honor, I would advise him not to speak on the matter we were just discussing.
Okay.
I assume is what he's about to speak on.
I would like to speak.
Okay, Mr. Willis, sir, let me explain. You've got an outstanding attorney beside you. Any attorney in this room would say, no matter what you think you're going to do right now to help you, we're being recorded. Somehow or another, it never does seem to help. Simple statements like, I didn't know it was there, or all of a sudden they then can argue that you were in the car. There's just so many variables to so many things when you speak out loud on the record. I'm not trying to prohibit you from speaking, of course, but I need you to understand, sir, your attorney, any attorney would sit and say, please let me do my job. And don't
Your
call.
Honor, just to advise the court, he wants the court to be aware that any allegations of alleged illegal substances that were found were not his, and someone else is and will be taking the blame for them.
That's, I understand. That's through his attorney. Okay, at this time, sir, you are entitled to a bond under count one. I will set bond in the amount of, show he has, I guess there's one case that they're reviewing for possible pickup, but he shows that he's qualifying as a low risk. I don't show any Florida cases or DOC cases. I'll set bond in the amount of $3,500 under count one. Bond will remain the same at $2,000 under count two and $1,000 under count three. You're not to possess any weapons or firearms, and you're not to possess any or consume any illegal substances. Okay? All right, sir. And was there, did the state wish to be heard further?
Your Honor, per the face sheet, it seems as though he will be returning to Ohio, just so the court is aware, so he can travel.
I saw that, and it looks like there's a pickup also, so it'll be interesting to see.
So, no, just so that the defendant can leave the jurisdiction.
Okay. Okay, so, yeah, I'm not putting any requirement that he cannot leave the state of Florida, but you understand you need to stay in contact with your attorney and return for all your court dates. Correct. And if you go back, okay, I think the last, oh, no, we've got, yeah.
Your Honor, there's actually one of the resets for tomorrow made it, and I haven't had a chance to discuss the plea offer. I'm not sure if he does wish to take it, but he is here to handle the case.
Can you tell us who it is?
Yes, it's Alun Volsey.
Okay.
Last name.
Yes.
Did I say it wrong, Alan? Okay, sorry, Alan Volsey, Volcy.
I think he had an out on bond too, did he?
Let's see.
No, I don't know why. I remember looking at,
He did have an out on bond.
there you go. I think that was, yeah, and I think it was a disorderly, this one, or trespass. Okay.
And, oh, he's taking the offer?
She's gonna speak to him.
No bond.
care of all those that they gave you? Yes. You don't have to. Wasn't very many. No. You thought they might add more, they didn't. Dare shut the computer down.
And, Your Honor, we're ready to proceed.
Okay. All right, sir, would you tell me your name again?
You have to say your name again.
Alan Volsey.
All right, Mr. Volsey, sir, you're here on a charge of providing false identification to a law enforcement officer. And at this time, Public Defender's Office is appointed, and how is your client wishing to proceed?
Your Honor, he'd like to withdraw any previously entered pleas and enter a plea of no contest. The state has offered a withhold of adjudication credit for any time served.
And is this the agreement of the state?
Yes, Your Honor.
All right, Mr. Volsey, sir, at this time, it's my understanding you wish to accept that offer. Is that correct, sir?
Yes.
All right, sir, it's my understanding you wish to plead no contest to this charge of providing false identification to a law enforcement officer. And is this your signature on the plea form, sir?
Yes.
Did you understand the rights that you're giving up by entering the plea today?
Yes.
And do you have any further questions regarding those rights that you're giving up?
No, ma'am.
Are you freely, voluntarily doing so?
Yes.
And are you under the influence of any alcohol, drugs, or medication that could affect your thinking today?
No, ma'am.
I'm sorry? Okay. And also, do you understand, are you on probation for anything?
No.
And do you further understand that by entering a plea today, if you're not a U.S. citizen, it will subject you to deportation if you're not a U.S. citizen?
I understand.
Okay, sir. And knowing all of that and knowing the rights that you're giving up at this time, sir, and I do find sufficient facts to take the plea, how do you wish to continue with your plea?
No contest.
I'll accept the plea. I will at this time withhold adjudication. I'll sentence you to the 2 days, no, 1 day. Today's the 18th, right? You got 1 day, because you got booked in. It's the same amount, don't worry. You got booked in at right after midnight. I sentence you to 1 day in the Orange County Jail with credit for 1 day time served. You'll be released on today under that case. Now, there's mandatory court costs, and I'll give you 1 year to pay those payments, to make that payment. You may want to go to the clerk's office, though, and start a payment plan well in advance of that if you can't just pay the whole thing off, okay?
Clerk's office.
All right, sir. Yes, sir, the clerk's office. Yes, sir.
Otherwise, they'll suspend your license.
Yeah, because they will. They'll suspend your driver's license if you don't. At this time, I won't take any action, or was there any request? State, you agree, no action on the out on bond?
Yes, Your Honor, no objection.
Okay, and so I'll take no action. You've pled to the new charge you were booked in under. You have the right to appeal the sentence of the court. You must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed to represent you, okay? Just make sure you remember to keep all your court dates on the open case, all right?
Stay in touch with your attorney.
Got to. Thank you. I appreciate it.
Of course, you're going to go that way.
Sir.
And Your Honor, we just have those two
Yes.
competency cases in the 33-day motion.
Correct. Okay, the first one was the Anthony Harris.
Yes, Yes, Your Honor.
And in that case, the court found PC, mental health, and you said there was a competency case.
He has a couple cases. I only looked into one personally. And I can give you the number of the one I looked into as well as some of his others.
And so he's currently been found, it's not a status, he has been found incompetent.
Yes, Your Honor, there is an order finding him incompetent. The one I was referring to is the most recent amended conditional release order, which references the original order finding him incompetent.
I'm gonna just pull it up, if I can, my finger here, pull it up. And let me get into the cases. So it's 2022, I think you said?
So for Mr. Harris, there's a couple cases, but the one I was looking at was 2021
Okay.
CF.
I'm sorry, CF.
2021 CF 00
Okay.
7879 AO.
Okay. Just want to see what the orders say. Oh, in fact, they just did a. Okay, so that,
Those may have been the amended conditional release orders. but if you
Right.
Look at it, it has the original.
I see that. Okay. So in that order on the 13th, it's crazy. Okay. Oh, I can't. Wish I could. My order's coming up, not, can you all click the order from, I see 713, is that the one you're talking about?
Let me pull that up. I was seeing if there's any more recent ones in his other.
Because on 713, it says defendant to attend Aspire and asked to speak to Brianna Wells?
She's, Your Honor, prior to coming to work down here, I did work in mental health.
Okay.
So she is one of the Aspire representatives. One of the contacts we get them into.
Okay, all right. Agreed, Aspire has not made contact, defense received contact. Yeah, I can't read the court order because it's one of those that prints out that long way on the computer that I can't see. You know, it's not been uploaded or it's that oddity. Okay. And the state's position on the court ROR and with those same conditions, because if not, it's going to violate. Looks like the CF case is pending with those orders.
Understood, Your Honor, but I haven't seen anything that says that you cannot give him a bond on this case.
Correct, and I'm at the point of looking, I understand, with absent that argument. Absent the argument to ROR, and then I did not know there was already you stated there was the order on it, but there's some conditions of that.
Yes, Your Honor. So if someone is found incompetent to proceed via case law, and I can go through Smith versus State with Your Honor, but generally speaking, they are entitled to be released on conditional release, not to be held at a bond. So for that, we would be, instead of phrasing it as released on their own recognizance, Your Honor, yes, we would just be asking they be put back on conditional release with the same conditions that they were previously, or however Your Honor wants to state it. Either way, that based on the case law, he can't be held at a bond. He's been found incompetent to proceed. Once he comes back, whether it's a new law, he should be released on his own recognizance, his defense's argument.
Your Honor, that was not my interpretation of the reading. That wasn't my interpretation of the reading, Your Honor, of the case that defense provided to me. My interpretation was, because in the case that defense cited, the defendant was going to be held until they could determine whether or not she could be committed to DCF. And so they were trying to determine whether or not the conditions should be modified or she could be committed. But it had nothing to do with the new, with regard to, if you read the paragraph, Your Honor, it says, this leaves the trial judge with only two options: modify the conditions of release or involuntary commit the defendant to DCF's treatment. But that is with regard to the offense that someone has already been found to be incompetent on. It does not address the new law offense, Your Honor. That is my interpretation of the reading.
And I understand both your arguments. I don't think I have to get there today because of IROR with conditions of release. I believe I can do that without addressing the issue of, it's still a condition of release.
Okay.
But I want to see the order. I don't know. Huh? The date 7/7/13. Yeah, I guess you all. There was just a competency hearing held. I'm showing just looking at the court order or looking at the clerk screen in front of Judge Lattimore. Would that sound like that would be logical? Does she do the competencies?
Judge Lattimore's so Judge Lattimore has a competency division. So once someone is declared incompetent, not prior, but once they are declared, they go into that.
That's the mechanism. That's the mechanism I'm trying to follow on this case. So not to send it to her, but just those conditions.
The only issue is if it's a misdemeanor.
Right, they cannot be, I know.
It's, yes.
I got you, I know.
Not yet. Okay. We will be doing.
Okay, the order's not uploaded. So the order's not uploaded. So at this time, let me look at one other case. Well, it comes, can't you all print that little screen that there's a, when I look at it in the clerk's office, there's this white little box that it's all typed up in. Yeah, and that won't print? Yeah, I'll take that. It'll give me just, yeah. I don't know what, I didn't know what it was called. Thank you. That was what I was, it was so small on that screen. Okay. Just want to know what it says. Released on own recognizance. Yeah, I can't, it's not coming up. I'm not able to pull up anything further from that. At this time, what the court's gonna do is I'm gonna ROR, I'm gonna take no action on the out on bond case. I'm gonna require Harris not to return to the scene of where this occurred, not to have any contact with the victim in the matter, and to comply with all competency requirements under 20. Thank you. Will they, does the state know? Will they go and do individual, will they pull the competency reports like they used to do from the most recent case?
I apologize, Your Honor, I don't know.
Okay, I just was curious how they're gonna, all right, we have one other that has been found incompetent, is my understanding, correct? And also 2023 MM346AA.
This is another one that's been found incompetent, I believe, in another case, not the one we're here for. Oops, I left that.
So your argument, the court cannot keep a bond at 500?
I would be arguing that because he's been found incompetent to proceed, that continues forward unless he's been found competent to proceed since then. And therefore, there are only two options: conditional release, ROR, for misdemeanors, generally speaking, and then state hospital. And of course, ROR can be conditional release with conditions.
Okay, all right. On the trespass to leave, at this time, in the state's argument, that is not what that case says.
Correct, Your Honor.
Okay. I will appoint the public defender's office to represent. He's got a previous trespass, told not to go back. I will observe him standing on the sidewalk. At this time, I will ROR. Can you just tell me where that other competency case is, what the last one is? I'm just curious.
Yes, Your Honor. The one I pulled was 2022 MM 0005455AA.
And what's going on with it?
And if I can show the state first, I actually printed the order in this
Yeah,
one.
that'd be great.
And if I may approach.
Sure, yeah. Thank you. Thanks a lot. Okay. So it looks like it was the same address as this one.
Yes, Your Honor.
Okay. All right, on this court order, I will, as I stated, I'll ROR at this time and do not return to the scene of where this occurred. And to the state, your office can look at reviewing a request for status under that case, since he's picked up the new charge also.
Okay, thank you.
Under the same location. All right. I believe, does that conclude our docket for today then, everyone?
No, Your Honor, we still have
Oh,
to do the
33.
33J motion.
I had a big smile. Did you see me? I was like, you're like, not so fast. Not so fast yet. All right. And if we would like to, if you want to go ahead and announce them, that would be of great help.
Certainly,
And
Your Honor.
Thank you.
Beginning with Cecile Benet Morris, 23 CF 4116, denied, information was filed. Andy Junior Pizarro, 23 CF 7991, denied, information was filed. Sean Lamar Siegel, 23 CF 8018, granted, notice of non-filing. Jermichael Anthony Wright, 23 CF 5900, granted.
I'm sorry, I've got these out of order. They're right.
Yes, Jermichael Wright, 23 CF 59.
I've got to find it because
Oh, who do you have next, Your Honor?
I have Velez Castillo.
Let me go look. I don't have that.
Okay, let's skip over that one. Do you have Santiago? George Quiones Santiago?
I think I've seen that one. Yes, Your Honor, 23 CF 7945, that should be granted.
Okay,
Notice of non-filing.
all right. I have Jason Brown. Are we in any order the same at this point? We're not, are we?
No, Your Honor, so it's okay, I'll just go hunt.
Thank you.
And I apologize.
It's,
I appear not to have, oh, Jason Brown, 23 CF 8014, denied, information was filed.
okay. I have Anderson next. Keelan.
Okay, I think we're back in order. 23 CF 8060, denied, information was filed. Dominique McNutt.
Yep, I'm good.
23 CF 8085. Your Honor, can you tell me what the date is on the order, please?
The date on what order?
On the order for the motion, it should say should be released on a particular date.
The defendant is released this 33 on July the 20th, so why is that filed? Wait, what is this saying?
Dominique McNutt.
The defendant's 33-day, the defendant's,
That's fine, Your Honor. It can be granted.
well, do you want the defendant's 33-day? Is that the portion you're talking about under the granted?
Yes, Your Honor.
Yeah, it says the defendant's 33-day is July the 20th.
That's fine, Your Honor. That is the 33rd day.
Okay.
This is something the public defender's been doing. So they file it early and we hear it early, but he does not get released until the 33rd day.
So he won't, even though I'm signing it early?
I believe
trust that to
corrections.
occur?
Yes, corrections. The jail does check these before they're released, Your Honor.
Okay, so you do have no objection to me signing this, today's July the 18th?
Yes.
Granting that?
Yes, because the order says that he will not be released until the 20th.
Okay. It just, well, it says to be released on their own recognizance if an information is not filed by the 33rd day, and then the defendant's 33rd day is the 20th.
Yes.
Okay. I did not pick those up. Were those from yesterday that we had these type of things? I don't think we did.
No, Your Honor, it's not done on all cases, and
Okay.
it's not an issue.
It'll just give me something more to look at, I think. All right, so
Is
let's,
your-
I'm gonna date these now that we're, okay,
Is your next one Timothy Lyman?
it is.
23 CF 8110, granted, case was no billed.
Okay,
Jason Anthony Beal, 23 CF 7155, granted, notice of non-filing.
that's Jason Beal.
Yes, ma'am, Your Honor.
That's okay. I just,
Marvin Noel, 23 CF 7896, granted, notice of non-filing. Reginald Duggar, 23 CF
okay,
79.
now we're back out of a different order.
Okay. Who do you have?
I have Bookard,
Brian Darnell,
correct.
23 MM 3467, granted, case was no billed. Alma Mater,
Yes,
23 CF 8063, granted, case was no billed. Jeffrey Dean Fuller, granted, case was no billed. 23 MM 421 AW, should be granted, case was no billed. Dondrick Dion Hooks,
yes,
23 CF 5269. He has a second case, 23 CF 7769. Both are granted notice of non-filing.
okay, let me just date those, today's date. All right,
I next have Lorenzo Combs.
I do also.
23 CF 8053, granted, notice of non-filing. Robin Renee Richardson, 23 CF 5273, granted, notice of non-filing. Gilbert Lebrun, 23 CF 8023, granted, notice of non-filing. Willie Everett Roberts Jr., 23 CF 8153, granted, notice of non-filing. I next have Reginald Duggar.
Reginald Duggar.
You can tell me who you have, Your Honor.
I will do Reginald Duggar. I have
23 CF 7917,
yes.
granted, notice of non-filing.
7917,
Yes, Your Honor.
and that should be granted.
Yes, Your Honor.
It's just a different format, so I've got a circle instead of, okay,
I don't think so.
all right.
Troy Lililes, 23 CF 7888,
I have that.
Granted, notice of non-filing.
Okay.
Keontae Pitts, 23 CF 7860. Granted, notice of non-filing.
That's 7860.
Yes, Your Honor.
Granted. Let me,
You have Juan Valdez.
I have. Yes.
That is a city case, Your Honor, but when last I looked, information had not been filed, so it should be granted.
Okay.
I think you mentioned one that I did not have. If you could give me that case number again, please, Your Honor?
I don't have any left. Who? Valdez?
That's the one we
Do you have
just
the
did?
case number?
Was it not?
It's too much of a. I probably.
Okay.
You have a good memory.
The first two. Pizarro.
Oh, I did, yeah, he's Valdez, yeah.
Brown, number 15, I think, and then Anderson was also.
The next two that
I don't think I've seen a Siegel.
Juan Elias Valdez Castillo?
Is that an MO?
Yes, that,
Yes.
you just granted, yeah,
Yes.
that was a city case.
Yes, Your Honor.
That's all I had.
So you don't have anything left?
No,
Oh, all right.
which case, tell me the name of the person that.
No, I have one for a Jermichael Anthony Wright, 23 CF 5900.
that's on my list as well.
Okay, we can address it tomorrow.
Your Honor, I do have that one on my list as well.
You do? Well, I guess we need to
Did you say you
have
had a
the
Siegel?
clerks look us up one or see if we've got.
Yeah, I have a.
Oh, wait, was this it? Okay, that's that incompetence. Did you want that case back on Mr. Sims, or can I just,
You can have it, Your Honor.
I'm gonna just talk. It's right here.
I don't have that. Oh, it was
It's
granted.
at the bottom. I do have that case.
Okay. 23 CF 5900, granted, notice of non-filing.
All right, and I have signed off on that one also. Were there any other matters?
Not from the state.
Anything from the defense?
No, Your Honor.
All right, everybody, thank you very much. We will stand and adjourn then. Thank you. And sir, your name, please?
Jeremiah Birch.
All right, Mr. Birch, sir, we reset you. This was from yesterday. It was possession of an alcoholic or an open container. And at this time, the Public Defender's Office,
There is an offer, Your Honor, of an adjudication of guilt, credit, time served, and Mr. Birch would like to accept the state's offer and enter a plea of no contest.
okay.
No contest.
Okay, and it was an adjudication of guilt and credit for time served in court?
Yes, Your
costs?
Honor.
All right, and he has, I believe, I don't know, how much time served?
Must have been 3 days. Maybe 3.
3 days, okay. And was the PD appointed on him, or are you acting as a friend of the court?
I believe yesterday you appointed us, Your Honor,
Okay.
because you found PC.
Right. I'm just not, I mean, look, I don't see it on the paperwork, but it's probably right there.
Either way, Your Honor. I can do
Okay,
it.
I don't see it. Do you want to just act as a friend of the court?
Yes, Your Honor.
Let me
Save him the fee.
Yeah, let me just rephrase all this. I don't see it marked off
Okay.
on the sheet.
Yes.
Okay. At this time, sir, it's my understanding you wish to plead no contest to this charge. Is
Yes.
that correct, sir? And is that your signature on the plea form?
That is my signature.
All right, sir. And did you understand the rights you're giving up by pleading here today?
I did too.
Are you entering the plea on your own free will because this is what you want to do?
Yes, ma'am.
And is anyone forcing or threatening you to do this today?
Not at all.
And are you under the influence of any alcohol, drugs, or medication that could affect
Hell
your thinking?
no. No, ma'am.
Okay. Are you on any kind of probation at all? Are you
Not
on
at all.
All right, sir. At this time, I'll accept your plea. I will adjudicate you guilty. I will sentence you to the 3 days you served in jail, 16, 17, 18. 3 days in jail, credit for 3 days. You'll be released today on this case. Now, they're going to take the financial obligation, and I'm going to put you, I'll give you 1 year to pay that, okay? Now, you can go up to the clerk's office, you know, downtown or closer to a Popcorn and, or Winter Park, of course, and get a payment schedule before that 1 year date to, you know, but make sure you do that before that time.
Thank you,
if you need a
Your Honor.
payment, okay?
Yes.
All right, sir, you'll be released today, and based upon the plea, is there any request on the out-on-bond cases?
No action, Your Honor.
Okay, so no action on out-of-bond cases, fled to, you know, this MO case. All right, thank you. You're welcome. Okay, so I believe we have everybody here now for the session. Okay, your name, please? I'm sorry, can you talk a little loud?
Yeah, Benjamin.
Benjamin?
Yes, ma'am.
All right, Ms. Benjamin, you are here on a charge as follows. Okay, you are here on a charge as follows. It is a charge of aggravated battery with a deadly weapon and battery, domestic violence. And I don't believe anybody's here. Don't see anybody. At this time, you do qualify for the public defender. I will appoint the public defender's office to represent you. And just again, for the record, once again, I don't ask each state and the defense, you know, I don't state your position or defense your position. You all just please, I don't want to use the word interrupt, but just get my attention or speak and say, Judge, may I be heard on each specific case, okay? Sure. So at this time, I'm going to order at this time, Ms. Benjamin, the following requirements. You are not to have any contact with the victim in this matter. Do you understand that?
Yes, ma'am.
And you understand that's directly or indirectly, no social media, no texting, no, you understand no contact means no contact.
Yes, ma'am.
And you signed the form that is on, you signed that no contact order?
Yes, ma'am.
And you understood that, is that
ma'am.
correct? Okay. At this time, I will also require you to maintain a separate residence. You are not to return to the scene of where this occurred. Do you understand that also?
Yes, ma'am.
And I'm also going to require you not possess any weapons or firearms.
Does she have that one-time return, Your Honor?
I'll allow you to return one time with law enforcement to pick up your personal belongings. Now, when you do that, don't go, you know, don't go there and then call law enforcement. You contact them first. They arrange the time and the place, and then at their direction, they will then escort you or meet you to be able to pick up those personal belongings. Do you understand?
Yes, ma'am.
Okay. Just don't want you down in the driveway saying, I'm here. You have to wait for their response. At this time, I will set bond in the amount of $3,500 under count 1 and $500 under count 2, with those as the conditions of your release under both of those counts.
Your Honor, DCF was contacted if she could comply with any DCF plan?
Sure. I'll also require you to comply, in addition to those other orders, to comply with DCF, okay?
And Your Honor, given she has no criminal history, could we set count 2 as a subsidiary of 150?
Does the state have any objection?
State would object. She stabbed someone in the back, Your Honor.
Okay. Okay. Thank you.
You're welcome. All right. Your name, please? Your name?
Jacquees.
Mr. Jacquees, sir, you're here on a charge of aggravated battery on a pregnant person and battery, count 2. Probable cause has already been found. I will appoint the public defender's office to represent you on the matter. I don't see any witnesses or anybody coming up. At this time, sir, I'm going to set bond in the amount of $3,500 under count 1. Count 2 will be $500. You are not to possess any weapons or firearms. You're not to return to the scene of where this occurred. You're not to have any contact with the victim, and you must maintain a separate residence. Okay? It's Division 16 and PC was already found. It was an arrest warrant, right?
This one.
Your name, please?
Kimberly Rivera.
Ms. Rivera, you are here in case number 2023 CF 960580. The charge is aggravated battery. I have reviewed the charge and affidavit. I do find probable cause. At this time, you do qualify for the public defender. I will appoint the public defender's office to represent you. At this time, I will set the bond in the amount of $3,500 with the following conditions. You're to have no contact with the victim. Do you understand that?
Yes.
And you've signed that no contact form. I saw you sign it just here at the podium. Is that correct?
Yes.
And you understood that?
Yes.
Okay. I'm also going to require you to maintain a separate residence. You're not to return to the scene of where this occurred, and you're not to possess any weapons or firearms, okay? Those will be the conditions of your release.
in the house.
Could she have a one-time return with law enforcement to gather any belongings, Your Honor?
Yes, I will allow you to return one time with law enforcement to pick up your personal belongings when you, that's okay. I just want to make sure she understands. If you, I'll let you speak with your attorney in just one moment. I just want to make sure you understand that. When you do go back and contact law enforcement, you contact them first. They will arrange when and where to meet you to pick up your personal belongings. Don't just go there, you know, and call them at that time, say, I'm here. You must arrange that in advance and wait for their further instructions on how they will meet you to gather those personal belongings, okay?
Ma'am?
Your attorney might want to, you might want to ask your attorney first because we're being recorded. And she may not want you to say anything to be used against you.
May we approach, Your Honor, on this case? Can we approach?
Sure. On or off? I leave on there and it really just tear it off. Yeah. It's my notes.
Y'all, the next on the docket was Adeping Kamani. He's currently on mental health status.
Okay.
Defense will waive, Your Honor. I would just ask for bond or mental health pretrial release, given the facts of the case.
Okay. Does he qualify for any mental health release, or will they process at that time?
Yeah, they have to be screened for.
Screened for. Okay. Any objection on behalf of the state?
No objection from the state.
I'll set bond. This is the matter of Adeping, and it's MM 2023-520AW. I'll set bond in the amount of $500 or mental health pretrial release if eligible. No contact with the victim. Maintain a separate residence, not return to the scene, and not possess any weapons or firearms. Okay.
And one-time return, Your Honor.
And allow one time to return with law enforcement to pick up personal belongings. All right. Okay, your name, please.
Anthony Baker.
Mr. Baker, sir, you're here on a charge of battery, domestic violence. This is in case number 2023 MM 5091AO, and at this time, sir, you do qualify for the public defender. I will appoint their office to represent you. Let me get this in order here. At this time, sir, I'm going to require you to have no contact with the victim at this time. Do you understand that, sir? And do you understand that?
Excuse me?
Do you understand the court's order of no contact?
Yes, ma'am.
And you've signed the no contact order here in open court, and you understand?
Yes, ma'am.
Okay, sir. I'm going to also require you to maintain a separate residence. You are not to return to the scene of where this occurred, and you are not to possess any weapons or firearms. Do you understand those conditions of your release?
Yes, ma'am.
Okay, sir. At this time, I'm going to set bond in the amount of $750 with those as the conditions of your release. The public defender's office is appointed to represent you. Okay? I'm sorry? Oh, okay. The microphone maybe can be pushed toward them. They're not able to pick them up. He was real soft-spoken, but thank you, I didn't, yeah. Your name, please?
Maurice Irvin.
Okay, I presume they'll let you know if they can't hear him. Just everybody talk, they're having a little difficulty hearing from the podium this morning. At this time, sir, you're hearing case number 2023 MM5093. It is a charge of battery, domestic violence. At this time, I've reviewed the affidavit. I do find probable cause. Public Defender's Office is appointed to represent you. I'm going to require you, sir, not to have any contact with the victim in this matter. Do you understand that, sir?
Yes, ma'am.
Okay. And you're signing the no contact order here in open court. And I'm going to just inquire about that once you sign it. Did you read that and understand that? I'm sorry?
Yes, ma'am.
Okay, sir. And I'm also going to require you, sir, to maintain a separate residence. You're not to return to the scene of where this occurred, and you're not to possess any weapons or firearms. Do you understand that?
Yes, ma'am.
Your Honor, there was a
He?
child.
Oh, sorry, go ahead.
There was a child that was involved, so DCF should have been contacted.
Okay.
If they do become involved, I would ask that he comply with any DCF plan.
Sir, if the Department of Children and Family Services does become involved with it, they may, I don't know. That's a different entity. I'm going to require you to comply with their directive, okay?
And, Your Honor, he lives in Indiana. Can he be allowed to return? They're just here on vacation.
Yes, he's allowed to return. Stay in contact with your attorney. I'm going to set bond in the amount of $750 with those as the conditions of your release.
What you say?
I said 750. Okay. Okay. Your Honor, defense would ask if you would set the bond at 700 because he's out of state. He has to pay the full amount. He has 700 in cash on him. Would you be okay with setting the bond at 700 as opposed to 750?
I don't mind. 700's fine.
He qualifies for PTR. He didn't want that?
Oh, I didn't know if
Yeah, but.
we're gonna give it.
Oh.
Yeah.
I would ask for pretrial release, but I didn't know.
I know. I see he qualifies, or they've got, yeah. But I'm looking at the out-of-state history, and I'll decline it, the request.
700?
700.
Thank you.
Okay.
So 700.
All right. Your name, please?
Richard Kenny.
Mr. Kenny, sir, you're here on a charge of battery domestic violence. I reviewed the charge and affidavit. I do find probable cause. I will appoint the Public Defender's Office to represent you at this time. And ma'am, if you would raise your right hand to get sworn in, okay?
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
State your name for the record, please.
Ashley Bernier.
Okay. And does the state wish to inquire?
Yes, thank you, Your Honor. Good morning, ma'am. Do you need a moment? Okay.
I didn't want to get him arrested. He was sleeping in the office. Was handcuffed him. So I was like, let him sober up. He's sleeping. I put handcuffs on him and took him away.
I can't hear anything.
Sorry. I said I told him not to. He was finally sleeping because he was super drunk. And he was attacking me. And so then I said, oh, he's sleeping. Let him sleep and sober up and get it out of his system. And then they just went in and woke him up and put handcuffs on him. I didn't want him arrested.
Ma'am, I just need to ask you a few questions.
Yeah.
How do you know the defendant?
Oh, we're boyfriend and girlfriend.
Do you live together?
Mm-hmm.
While this case is pending, do you want to continue living together?
I do, but I don't know if he does. His one daughter hates me. His other daughter is on my side, so I'm there by myself with cats. I'm a pretty boring person. Trying to get my disability back.
You indicated that he was drunk, so alcohol was involved in this incident?
Yeah.
Has something like this happened before?
Long time ago. Like when we first started acting, we've known each other for like 10 years at least. And then we were technically dating for almost 3 years. So it hasn't been like super violent or difficult or anything like that.
Okay. I have no further questions. Thank you very much for coming in.
Thank you.
I'm just curious, what do you call super violent?
Well, he was, I told him he was really drunk and he wanted to, on Sunday during the afternoon.
No, I don't mean to interrupt, but you said it never like, you said something
No, like,
in the
I've never
past.
been violent to me in the past. I've never been violent to him. Maybe we'll slap each other and joke around and stuff, but never anything really violent, anything like that. So he was super drunk during the day on Sunday. So he was falling into the bushes and he was laughing about it. So essentially, we both wound up going to sleep and he said, well, he had all these cuts in from the bushes and I cleaned him up for him. He said, I should probably go to the hospital and get a tetanus shot because I don't want to get an infection. And then there, he just went crazy in the room. So I was like, he just walked out of the hospital and I followed him. I said, I'm driving home. And so then I said, don't maybe call Ruthie. Ha ha. That's his one daughter that's been sober for over 3 years now.
That's okay, you can slow down, that's okay, I just needed.
He just like started hitting me for some reason.
Okay.
Beating me and my bruises and I was like, whatever, it'll be fine. It'll be fine. So, yeah.
All right, thank you.
Thank you.
No question.
Okay.
He qualifies for pretrial release, defense would ask for pretrial release.
Can they do random UAs on pretrial release still?
Yes, Your Honor.
All right, does the state have any objection to pretrial release with including random urinalysis and
No, Your Honor.
alcohol?
And, since it was alcohol, it's just the alcohol testing? Or are you doing both?
For drugs, you mean? No, I mean,
Okay.
have-
I didn't know if you were doing alcohol
No,
testing. or-
no, I'm doing alcohol,
Okay.
random testing. They can choose
Okay.
a breath test, they can choose urine, I'm gonna just
Okay.
put, random testing.
Thank you.
Okay, no problem. Sir, I'm gonna require you to have, does the state object to no violent or hostile contact?
No objection, Your Honor.
I'm gonna require you to have no violent or hostile contact. Do you understand that, sir?
I do.
Okay, sir. I'm also going to require you, sir, not to consume or possess any alcohol. Do you understand that?
Yes, Your Honor.
And you understand, sir, the pretrial release that I'm going to order will include random you just heard me, your attorney was asking, an appropriate question, for clarification regarding that. But you are to consume no alcohol and you're going to be subject to random testing. Do you understand that?
I do, Your Honor.
And you understand if you violate any of the court's order, the pretrial release will be revoked and the bond will probably set at 0. So you won't be able to bond out, in other words. Do you understand that?
I understand.
Okay, sir. I'm also going to require you, sir, to not possess any weapons or firearms. All right? Okay, sir. Thank you. Thank you, ma'am. And, yeah. Sir, your name, please?
Gusto.
I'm sorry, what was your last name?
Oh, my last name, Rivera Tovar.
Okay. You're here, sir, on the following case. It's 2023 MM 5077, and it is a charge of 2 counts of battery, domestic violence. And at this time, sir, if you'd raise your right hand to get sworn in, please.
Do you swear to tell the truth, the whole truth, and nothing but the truth today?
I do.
Could you please state your name for the record?
My name is Juan Carlos Rodriguez Tovar.
Thank you.
All right. And does the state wish to inquire?
Thank you, Your Honor. Good morning, sir. How do you know the defendant?
He is my younger brother.
Do you live together?
No, we do not.
Does he live with your mother?
Yes.
Has something like this happened before?
A couple times before.
Were drugs or alcohol involved in this incident?
Yes, they were.
Was it drugs or alcohol, if you know?
I'm sure a little bit of both.
Okay. While this case is pending, do you want to have contact with him?
For the time being, no.
Do you know, only if you know, if your mother wants to have contact with him?
I'm not sure about that.
Okay, all right. I have no further questions at this time. Thank you very much for coming in.
Does the defense wish to inquire? I'm sorry, the public defender's office is appointed.
No, Your Honor, no
All right.
questions.
All right, thank you, sir. At this time, I'm going to require you to have no contact. Do you understand that with your mom or your brother? Do you understand that, sir? Do you understand that?
Yes.
Okay, and I know you were shaking your head yes, but we're just being recorded, so I
You're
have to
fine.
make sure the record's very clear. And you signed that no contact order in open court just now, correct?
Correct.
And did you understand each of those conditions of that?
Yes, ma'am.
All right, sir. No contact means texting, calling through a family, another family member, through a friend, flat out, no contact. I'm going to require you, sir, also to maintain a separate residence and not to return to where the scene of where this occurred. You're not to possess or consume any alcohol or illegal drugs. And also, sir, I'm going to require you not to possess any weapons or firearms. At this time, I will set bond on each count in the amount of $500 with those as the conditions under both counts, okay?
Could he have a one-time return to gather belongings, Your Honor?
And I will allow you to return one time with law enforcement to pick up.
I don't think you have vision impaired. He's vision impaired, so he's just trying to see what.
That's okay. I just,
Listen, pay attention though.
yeah, I'll give you plenty of time to do that. I just, when I give an order, my concern is always that I'm very clear and that people will understand, because if you violate the order, the bond will be revoked. So as an additional request, is my understanding, not only did you, I placed those other orders, requirements on your bond, I'm going to allow you to return one time with law enforcement to pick up your personal belongings. But when you do that, don't drive to the house and sit there and call law enforcement saying, I'm here to get my items. You call them in advance, they will arrange when and where and how that is to be processed, okay?
Is it possible if I could send my wife instead to avoid all that?
I don't have an objection if they don't have an objection. The wife?
I do not want her in my house.
Okay, then that's not gonna happen then, okay?
That's
All right.
perfect.
Thank you. I understand, that's fine. Right now, everything needs to stay in place. All right, thank you.
Your Honor, next on the docket was Rochelle Marceline. She's on mental health staff.
Okay.
The defense will waive
Oh.
and ask for a one-time return, Your Honor.
Okay. At this time, I'll appoint the Public Defender's Office. I will set bond in the amount of $500 with the following conditions: no contact with the victim, maintain a separate residence, not return to the scene of where this occurred, may return one time with law enforcement to pick up personal belongings, and not to possess any weapons or firearms, okay? Your name, please?
Dennis Lawson.
Mr. Valson, sir, you're here on a charge of battery domestic violence. At this time, sir, this is in case number 2023 MM 5094AO. You do qualify for the public defender. I will appoint the public defender's office to represent you. And if you would please raise your right hand to get sworn in. Do you swear to tell the truth, nothing but the truth, so help you God?
Yes, ma'am.
Okay, just thought I'd save you a little bit from having to get up every time. Okay, and your name, please?
Christina DeLance.
Okay, I know we just have to hear you.
Christina DeLance.
Okay, and if that microphone, if it helps you to move that a little bit forward, that might help a little bit. All right, and does the state wish to inquire?
Thank you, Your Honor. Good morning, ma'am. How do you know the defendant?
He's my boyfriend. My boyfriend.
Do you live together?
Yes, ma'am.
While this case is pending, do you want to continue living together?
No.
Okay. Do you want to have any contact with him?
No.
Has something like this happened before?
Yes, ma'am.
Apart from yesterday, when was the last time an incident like this happened?
I would say probably in May.
Did you call the police at that time as well?
No, ma'am.
Were drugs or alcohol involved in this incident?
I don't think so.
Thank you very much for coming in. I have no further questions.
Thank you.
Okay. Thank you. It's my understanding, you live somewhere else, correct?
No, we live together, but I just want to wait till the end of the. Sorry, we live together, but I just want to wait till the end of the month so that I can leave.
Okay.
So I'd ask for a one-time return.
Okay.
Your Honor, he can qualify for PTR.
He
also.
does.
Can we do pretrial release, Your Honor?
What is the state's position on that? He's got a history of battery and aggravated battery on a pregnant person. I don't know when that was. It just said history. I see the last conviction was in 2019, though.
I don't have any.
Oh, I don't have an updated one because.
Oh, am I looking at the wrong person?
I know.
Oh, I'm sorry. I am. Okay,
Right,
sorry
you
about
have
that,
any history
everybody. I was
online,
looking
so-
at the gentleman, well, maybe I have inadvertently. Can I see his? This is Valson. I've got Vincent, and then I go to Willis. So I don't see his face sheet. Can I see a face sheet then? Maybe that's what it was. I was looking at a V. Okay. Does he qualify for pretrial release?
Yes, his print's cleared.
Okay, that's what was holding him up. Okay.
And state has no objection.
Okay, I see that now. There is no history. All right, I'll allow pretrial release then. Okay. Sorry, I don't know what happened to that one there. I need to make sure, Mr. Valson, that you understand the court's order, though. I am going to require you to have no contact with the victim. Do you understand that, sir? I'm also going to require you to maintain a separate residence. You're not to return to the scene of where this occurred. I will allow you to return one time with law enforcement to pick up your personal belongings. Now, when you do that, sir, you contact law enforcement first. They arrange when and where to meet you to pick up those items. Don't just go there and call them in advance. They'll arrange when and where to meet. I will also require that you not possess any weapons or firearms, okay? All right, thank you, sir. And the public defender's office is appointed. Thank you, ma'am.
Thank you.
I don't.
In Florida, once you live in there, that's where you gotta go to come out.
Your name, please?
Emmanuel Vincent.
Vincent, sir, you are here on the following charge. It is battery. At this time, I believe there is another individual. Both of them got arrested?
He did.
Oh, yes, it's the next person, Your Honor.
Yes.
So we bring another person.
You want both of them in the courtroom?
Yes.
I think we probably do. Usually we do, yeah, just in case we have to inquire. Just everybody make sure they understand that they're each defendants. All right. Ma'am, your name, please? All right. So, Mr. Vincent, sir, you're here. You do not qualify for the public defender, they're stating. How much are you making every week or every other week?
Like 22,
Okay.
22 to 25 every
Okay.
2 weeks.
You don't qualify for the PD. We're going to address your bond, though, but you don't qualify for the public defender. I do show that Ms. Willis does qualify for the public defender, so I will appoint the public defender's office to represent her. I've reviewed each of your charge and affidavits. Ms. Willis, your case number is 2023 MM 522AW. At this time, Mr. Vincent, sir, your case number is 2023 MM 521AW. I do find probable cause as to each of these cases and count.
In Your Honor, Ms. Willis does not want contact, so I just asked for a reasonable bond and no contact. They don't reside together.
Okay. At this time, Mr. Vincent, sir, I'm going to require you to have no contact with Ms. Willis. Do you understand that, sir?
Yes.
All right, sir. And you understand that's directly or indirectly through a friend, through any messaging? any kind of Facebook, any social media, et cetera. Do you understand that, sir?
Yes.
No contact means no contact. I'm also going to require you, sir, to maintain a separate residence. You're not to possess any weapons or firearms, and I will, you each reside at separate residences, and you're not to return to the scene of where this occurred, okay? All right. And at this time, sir, I will set your bond in the amount of $500 with those as the conditions of your release, okay?
Yes.
All right. And at this time, Ms. Willis, as to your case, I do find previously stated probable cause, PD's appointed. I'm going to require you not to have any contact. You're to maintain a separate residence. I believe it was her residence.
Yes, sir.
Right. Maintain a separate residence, no contact, and no weapons or firearms. I'm going to set bond in the amount of $500 under each count with those as the conditions of each of the releases, okay?
Any objection to treating counts 2 and 3 as subsidiaries, Your Honor, given she has no other criminal history?
No objection from the state.
Okay. What I'll do, though, is, look which one I want. I'll do the 500, 150, and 150, okay?
Thank you.
Thank you. Your name, please?
Christian Cardona.
So you're here, what happened with Butler?
Butler, Your Honor, she bonded.
Okay, thank you. Mr. Cardona, sir, you're here, sir, on an out-of-county warrant. At this time, that warrant was issued, and that is set in St. Lucie County, and the bond is set at $5,000. You do have a bond. You can post your bond. If you do, make sure that you do attend your court appearances. If you're not able to post your bond, they have been notified or will be notified to go ahead and place a hold and pick you up, okay? All right, thank you, sir. Your name, please?
This is Corporon.
Mr. Corporon, so you're here on out-of-county warrants. These warrants were out of Polk County. Bonds have been issued under both of those. Count one is, or one of them is $1,000. The second is $500. At this time, you are on out of bond on an Orange County case. I'm inclined not to take any action. I don't know when that other occurred.
That's fine, Your Honor. We generally don't.
Right. Court takes no action on the out on bond case, so now you are able to post the bond if you can for the out-of-county cases, if you have no other holds here in Orange County. If you're not able to post the bond, Polk County is notified to go ahead and pick you up, but make sure you stay in contact with your attorney in Orange County. If you get to Polk County and get a sentence that you can't get out on, that you keep your attorney here updated so they know where you are, so that if you are in jail, they'll know the appropriate steps they need to take to locate and get you back here in Orange County, okay?
Yeah, so I'm like allowed to be released on bond. Like if I can get released here.
You've got a bond on them, yes, sir.
Okay.
I'm not taking any action on the out on bond case. The one that, the Orange County case was holding you until you saw the court at initial appearances, which was today, your initial appearance. So I now have lifted that hold, so you now are able to post bonds for Polk County, okay?
Oh, it's only for Polk, so I can't get released here?
I'm sorry?
It's only for Polk? Like I have to get transferred first? Is that?
Well, Polk County will pick you up if you have no other holds in Orange County, if you cannot post their bond.
Okay.
Okay?
Yeah.
Thank you, sir.
Your Honor, next to the doctor was Kelly. She's on mental health status.
Okay, that was a warrant out of Volusia County. So at this time, that bond was set at none. So I go ahead, they can pick her up if she's eligible for pickup. No other holds in Orange County. Your name, please? Mr. Hargrove, sir, you're here, this is an out-of-county warrant, sir, from Polk County. The court there has issued the warrant and set your bond at $2,000, okay? So they'll be notified to pick you up if you're not able to post the bond, if you have no other holds in Orange County. I do.
Bonded.
Okay.
Owens Gerald. Current on mental health status.
Okay, I'll go ahead at this time. Mr. Owens's case is a Volusia County hold. Bond is set at none by that court. Volusia County will be notified for pickup. Thank you. Gladys Willis. Okay, at this time, that court in Polk County has issued an out-of-county warrant for pickup. At this time, that bond was $500, so Polk County will be notified, of course, if she has no Orange County hold for pickup. So that bond stayed. Is this Mr. Sylvester?
Yes, ma'am.
Mr. Sylvester, sir, this is an out-of-county, or this is a fugitive from justice warrant. This is out of, I believe it was, somebody want to help me out? Would you all show? I believe it was corrections?
Wyoming.
Wyoming, okay. So they'll be notified. They're going to be notified. The section here, the fugitive section here will be notified regarding your case for pickup. So they will be speaking to you regarding that, okay? Is your office appointed on those? I didn't think so. Yeah, I didn't. They just go talk to them and see what the decision is, and from there they either get a warrant, governor's. All right.
Your Honor, Allen Walter refuses appearance.
All right, at this time, Mr. Welter Allen. This was a violation of probation, and that judge, this is in case number 2022 CF 2351AO. That judge has issued the violation of probation warrant and has set bond at none.
Defense will waive.
I'm sorry?
Defense waives the appearance.
Okay, thank you. And I'll appoint the public defender's office to represent him, okay? I believe there were 2 cases? Yes, 2 cases, so they'll both still remain at no bond with the PD appointed. Your name, please?
Sean Estington.
So you're here in case number 2019 CF 13328. I don't know if there's a 0. Let me look. And at this time, sir, the court that has issued the capias or the warrant has set your bond at none. I will appoint the public defender's office to represent you, okay?
Judge, he does have reporting requirements.
Okay. Who's talking? I'm sorry, I didn't, thank you. I'm like, where, who's, okay, so how does that done when they're incarcerated? Still to notify within 24 hours of release or now?
Yes, Your Honor.
Of release?
Once released, yes.
Okay, notification within 24 hours of release, all comply with reporting requirements. Sorry, I didn't see, I mean, I see you down there, I just didn't know who was talking. Your name, please?
Philip Scarfo.
All right, Mr. Scarfo, sir, I think I saw you yesterday.
Yes, ma'am.
That's correct, okay. You're here, sir, in that case number 2019 CF 5754AO, and at this time, sir, this was a violation of probation. This is a on view, I believe this one was, that is correct?
Yes.
Yeah. So at this time, the court does find probable cause of that you committed the new offense while on probation. The bond will remain at none at this time. I'll appoint the public defender's office to represent you, okay? All right.
Thank you, ma'am.
You're welcome, sir. And this is Miss, is this Miss Smith? All right, Miss Smith? Okay, Miss Smith, you're here in case number 2019 CF 17313BO. This is a violation of probation. The court, where you're on probation, has issued a warrant, has set your bond at none, and I will appoint the public defender's office to represent you, okay?
Yes, ma'am.
Thank you.
You're good. Yeah, you can do it. I'm just gonna look at my email.
I don't know what else we're doing. I don't have any other pieces of paper.
Yeah. I'm gonna make sure, yeah.
What are we doing?
Aren't we done?
Wait, that's, what? I don't have any other paperwork.
It is.
Oh, the PD? Oh. Okay. So we brought, okay. Your name, are you Mr. Burris?
Yes, ma'am.
All right, Mr. Burris, they've given me paperwork, case number 2023 CF 9205AO, and that you filed an affidavit of insolvency, I guess. One was filled out. What?
I don't have any notes. Oh, Judge McGinnis?
Yes.
Okay.
Oh, okay.
Okay, this said okay. Are you, it said he filled out one. So let me just ask, are you gonna hire your own attorney, or do you want me to appoint one?
Appoint one, ma'am.
Point one, do you have any money in a checking or savings account? No, and you're not working, obviously, because you've been incarcerated. All right, sir, I will appoint the public defender's office to represent you on this case then, okay? So you now have an attorney in case number 2023 CF 9205AO. All right.
Okay.
Your attorney may want to speak to you. We're being recorded. She probably doesn't want you to say anything to be used against you. So let her speak to you and give you that information, okay? No, it just said it'd been filled out. That's why. I mean, I'm just like, where's the paperwork? That's okay. Thank you. Yeah, see, it said, I thought, why have I got it? All right, I believe we are now, oh, okay.
Can we address the 33-day motions at the beginning of the second session, please, Your Honor?
Here. Okay.
Thank you.
I don't think it matters either. Okay, but let's move the second session up.
12?
I mean, it's 10 of 10. What sounds good for you all?
Or 12? Ortega?
Are you all okay with noon?
Ortega.
Are you all okay for noon, starting? Noon, 12? Yeah, we got 2 hours.
12 is good, yeah.
12 is good, give you all time to get everybody moved.
Not that many people in and out.
No, there's not near, compared to our yesterday, this looks like a breeze, doesn't it?
Yeah.
Now, okay, so what we want to do is make sure nobody gets these, I mean, no inadvertently, because I signed them all. You know, I don't care, I don't think anybody will inadvertently grab them thinking we've completed them, but let's hide them. All right, everybody, we'll stand in recess until 1, okay?
12.
I mean, 12, oh my gosh, 12.